Okay, good morning, everyone. Day 5 of the Roberts, Smith, Williams, and Brangman appeal. The appearances as before, and the proceedings are before my Lord President, Sir Christopher Clark, and Justices of Appeal, Jeffrey Bell and Anthony Smelly. My Lord President, you're muted, sorry.
Right. Well, good morning, everybody.
Morning. Morning, sir.
Good morning.
Good morning.
I think yesterday in the Smith-Williams list, we had got to
Maria Rewan.
Maria Ruin. Yes.
And that was to be found on our page 385 of the transcript in the record of appeal. And just to follow that through, we had Charlene Simons, who was stood by at line 6, and then Maria Rewan was called, and she was on standby, put on standby at line 9. And we see the observation made, and I don't need to repeat what I said about it yesterday. Next comes Altino Lopez. He is dealt with a little later, but he was called on at that point to replace the standby. He then took his place in the jury box, and the judge then proceeded to continue in the route, taking the route that he had previously by going along the line and asking people if there were still any problems. He was still on the front line, and at line 12 you can see he's asking effectively, still on the front line, madam, yes. And then a prospective juror says, yes, I have one concern. Yes, madam, with all due respect, I work for myself, I'm a part-time housekeeper, and so on. But she clearly remains at that stage. And then the court says, right, all right, down the front line, yes. And then another prospective juror, I have a job. This is at the bottom of page 385.
I'm sorry, Mr. Lynch, we can't, we're having difficulty hearing you.
Oh, sorry about that. Can I, let me see if I can turn the volume up a little. Oh, that's the highest it goes. Am I audible now?
You are now.
I have no problem here.
Okay.
No, Lopez was called on to.
I think that the problem might be, Mr. President, at your end, because you've just frozen and you're breaking up.
Oh.
And I think
You've frozen a couple of times, Mr. President.
Oh, Lord. Let's see if I can. Can you hear me now?
Yes.
yes, no problem.
Oh, well, I've gone on to a different system, so that may be better.
Good, all right. Well, I was at the bottom of page 385.
Yes.
Where a prospective juror was saying, I have job commitments. It runs over the page onto 386. From
just a minute. You were speaking about Altino Lopez.
Yes, Altino Lopez was called in to fill in the space of the standby that my learned friend had made.
What is that their ruin?
Yes.
Right, okay.
So he's got, but we come back to him a little later.
Back to him later. Yes, okay.
Yes, he's just taken the place in the jury box. And the process then is the judge going back through the front row of the jury box, asking potential jurors if there is any particular problem. And he's dealt with one. And then there's another one who says at the bottom of page 385, I have a job commitment from October the 10th to the 15th, and then travel dates, October the 22nd to the 24th. And that is our Keith Bridges, which is the next one on the list on our page 153 of the supplemental bundle of authorities.
Wait a
which has
minute.
The chart.
But wait a moment. The prospective juror at 17, line 17, is Barbara de Souza. Is she not?
Yesterday.
Yes, it is.
Right.
She expressed concern, but nothing happens. She simply says, "I'm part-time housekeeper." Okay.
Right.
She
Okay.
as far as I'm aware, she remains exactly there in the front row of the jury.
Right.
The judge saying to her after she's given that explanation at line 21, okay, and then
Right.
prospective juror, sorry, and then the court says, all right, down the front line, yes. And then again,
Right.
prospective juror at line 25.
Right.
Now that prospective juror is Keith Bridges.
Okay.
And then he goes over the page and he explains that I have job commitments from October the 10th to the 15th, and then travel dates October the 22nd to the 24th.
Right.
At that point, Mr. Mahoney says, stand by, at the invitation of the judge, who says, yes, prosecutor. He says, stand by. Now, pausing there, Learned Friend in his chart puts down Crown standby, job commitments 10th to the 15th of October, followed by travel. Well, first of all, the travel is irrelevant because the case had finished well before that, and we all knew, because the judge had made it clear, that he had commitments abroad before that date. I think I seem to recall his daughter was graduating or something of that kind. It was certainly something to do with a family member that he had to attend, and he was making it clear that he was traveling. And so those travel dates were never going to be a bar. Indeed, conviction was on the 16th of October.
So wait a minute. The judge had commitments when?
I'm not entirely sure of the exact date, but I know that it didn't fall into that he was not going to be available for the week of the 22nd to 24th anyway. If necessary, we can go, we could probably find a transcript, but I'm sure Mr. Mahoney will either recall or will be able to confirm those dates were not an issue in terms of commitment by the juror to being present in court for the trial.
When did the trial finish?
The 16th. Conviction was on the 16th of October.
Right.
But my lord, may I just interject? Usually you have forecast, but it doesn't necessarily mean that the trial will end before a particular date, because sometimes for one reason or the other, the matter is adjourned. Either a juror is ill and you can't proceed or something.
Yes. I entirely take that point. The problem here was that the judge himself had indicated he was not going to be available. He had a commitment abroad. I'm going to ask my junior to find where that is in the transcript, if she can, please, Ms. Tucker, because if it is in the slightest doubt, let's be clear about it. There was no issue of it running to that. I know personally, because I'd made arrangements myself to be abroad. I had commitments in the United Kingdom in the latter part of that very week. Now, I've just checked my diary, and flights have been booked from well before that. So, and I know that we canvassed all of this right at the very beginning of the trial as to what the commitments were. I say straight away, of course, if a Learned Friend wants to argue about it, by all means do. But those dates for travel were irrelevant. Certainly, that's our position. Simply asserting, as this particular jurist does, I have job commitments from the 10th to the 15th, is a meaningless statement in our respectful submission. We all have job commitments. That doesn't excuse us from our duty as jurors. And so it is simply not sufficient for my learned friend to now say that the reason why he invited this juror to stand by was because the juror said he had job commitments. I suspect that the majority of people on the jury had job commitments. Yes, thank you, Ms. Tucker.
The transcript reference is at page 4 of the actual transcript. I have the hard copy transcript in front of me. So the page 4 should be on, you should find it in your
just a moment. Yes. Let's have a look. Page 4 is 372 of the bundle.
Mhm.
Page 372. Starting at the top, let's have a look.
It's the paragraph starting at line 7, where the
It is expected to last. It's expected to last about 2 weeks. That's next week, because we are only going to select a jury today. We're not going to work tomorrow, so that means starting on Monday, we expect to use that whole week and a couple of days in the following week. We hope to be finished by the 22nd. If we are not able to do that, we'll have a break for the rest of that week and we'll complete in the following week. So we expect that we wouldn't be here later than the 26th of October. And so he was going to have a break, finish by the 22nd, but if we're not able to do that, we'll have a break for the rest of that week. I think that was the judge was indicating, or had indicated perhaps earlier, that he was going to be away, but he could come back if necessary.
But
What day of the week was the 22nd?
Monday.
That was Monday.
Okay. All right. Right. So you say that the fact that he was traveling on Monday, Tuesday, and Wednesday doesn't take matters any further.
No, and frankly, even if a juror does say I have travel commitments, the usual course is to say, well, what is it? I mean, if it was something that might be delayed for a few days, that would be the normal course. A judge would inquire, well, what is it? Is it pre-booked holiday, for example, or have you just earmarked it in your diary?
Mm.
And those are usual inquiries that are made when someone says that they have a travel arrangements or a commitment of that kind. The point is, I suppose, is that no inquiry is made at all. All that happens is that Mr. Mahoney says, stand by. In fairness to Mr. Mahoney, it's done at the invitation of the judge who says, prosecutor.
Right. But you're still saying, Mr. Lynch, that that's a Crown standby.
It is a standby, yes. It could be nothing else. The judge didn't say, defender, asking me anything. It was just, once the standby is done, it's done. All right, so after that, there is the next juror.
So wait, you say Keith Bridges is a Crown standby?
Yes.
Yeah, okay.
The fifth one, we say.
Yes. Right.
We have as yeah. So the next one then is Crystal Simons, and that's agreed by all parties to be a standby. We say the 6th, they say the 3rd.
Yes.
And then we get to page 386, we should be on. And then if we go to line 25, right at the foot of that page, the judge, having been through the line on the jury again, asking if anyone has any concerns, none, 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 none. You can see that above the line 25. And then he gets to line 25. And then we have respective juror says this: I've been seconded to the legal aid officer, and the court says, yes, prosecutor, and the juror says, and I'm sure that, and then Mr. Mahoney says, stand by. Mr. Mahoney doesn't accept. This is Linda Simons. Yes, my lord. And then there's a short exchange because the judge says, we were trying to hold on to you. And I say, so was I. And it is perhaps indicative of the power being wielded by Mr. Carrington Mahoney, that once he says stand by, that person goes to the back of the queue. The judge at that stage doesn't, as I understand it, have any authority to inquire as to whether that is a good standby or not. The person goes to the end of the queue, and if called again, that's the point at which the judge can inquire, well, why is this person being standby? Is there a cause or whatever? So that once Maloney Friend says standby, that takes the person out of the equation and certainly doesn't permit us to say anything under the position as it was then. So Maloney Friend does not, as I understand it, concede that that's a standby. We say it is.
Yes.
It is perhaps regrettable because both the judge and the defense wanted that juror.
Yep.
And then we move on. We come back to Mr. Altino Lopez, and we need to move on to the next page for that. No, it's at the foot of this page. So line 19, Mr. Lopez, who had been called earlier and was sat patiently in the jury box, the judge, having turned to him, says, yes, my wife has just been diagnosed, and this is the one who had all the various his wife had all these various ailments, and it's at that point that you're expecting to travel with her. Yes, sorry to hear about your concern, says the about your circumstances, says the court. Mr. Mahoney says stand by, and the court says yes. I accept, can I say straight away, that even though Mr. Mahoney said stand by, I would have invited the judge in any event to have permitted this person to withdraw from being a juror, given what they had said. So I don't rely on that as a standby. It's perhaps, as I say, somewhat regrettable that Mr. Mahoney did so as a standby, because this person clearly had cause.
Mm.
But I take no point on it. As I say, it doesn't matter. The person was excused, and that's what mattered, and rightly so.
Okay. Yeah, you don't rely on that.
I don't, no.
Okay.
But then the next one is at page 388. And at 388, line 21, towards the bottom, line 14, sorry, we're still at the jury box with the judge saying this jury box is so bad, it's not so bad. It's like flying JetBlue, a little more room than American, still no concerns, right, none. And then he gets to a particular juror, Siobhan Hollis, who obviously has an issue, and that person, as it were, says it's saying yes, or the judge saying yes, I'm not sure which it is, it doesn't matter. But Mr. Mahoney says at that point, stand by, sir.
Well, that can't be Siobhan Hollis.
No, it can't be.
Siobhan
I think
Hollis is female.
Wasn't that Janelle Parsons?
I don't know.
Well, it's obviously a male.
Yes, Janelle Parsons, I thought was a woman, which I think probably threw me. But at that point, at any rate, Mr. Mahoney is saying, stand by, sir. And then the court says, you might recall point number one might be gone by Monday, right? I don't know. It may be that there was a note. It may, I simply don't know. And it's omitted on its face from the the schedule that learned friend has prepared. I invite correction if Mr. Mahoney has some better clue of the position, or indeed Ms. Tucker, but I don't understand. I couldn't work out exactly what was happening at that point.
Well, yes, I can't work it out either. I mean, the court associate says number 24.
Janelle
Mr.
Parson was
Mahoney.
the fourth person. She actually sat. The standby was in reference to Lopes. Apparently, the judge did not hear what I had said before, so I had to repeat it. But Parson was the fourth person.
I see. So so that was a reference back to Mr.
Back
Lopes,
to Mr. Lopes.
repeating what you previously said.
Yes.
Yes. Well, I'm not going to argue about that. That seems not an unreasonable assumption from the material that we have in front of us.
Okay, so we needn't concern ourselves with Janelle Parson because she sat.
She sat, yes.
Okay.
She's one of the jurors. So I think that I'm perfectly happy to accept from Mr. Mahoney that he was referring back to Mr. Lopes and that he was stood down. And as I say, I take no point on Mr. Lopes being asked to, being permitted to stand down, given his particular circumstances.
Yes.
So we move on to Siobhan Hollis, which comes at the foot of the page after the judge has said you might be recalled. Point number one may be gone by Monday. I have that little issue too, and mine is going. So that might be gone by Monday. Number 1, 2 is more difficult. I think this is a reference back by the judge to his position in that following week. Anyway, it doesn't matter. Point number 2 is more difficult. You have my sympathies as far as that's concerned. I wish the best for you. Might not excuse you entirely, so you may take the seat. So you can just take a seat now.
Points number 1 and 2, Mr. Lynch, are matters referred to in the note that was handed to the judge, are they?
I think it must be. It must be, yes. That's what I have assumed, certainly.
Right.
And then there's an Ashley Lewis.
Well, wait a moment.
Sorry, before we get to Ashley Lewis, yeah.
I'm sorry. I have to take things in the proverbial stages. Are you relying on Siobhan Hollis or not?
No, the Crown said, they said standby, note written, Crown said standby, court advised that they might be recalled. So the standby reference above at line 21 on page 2388, Mr. Mahoney says relates to the previous Mr. Lopes.
Yeah.
In his schedule,
he says
that he asked, the Crown said stand by.
Those words do not appear in the transcript.
It doesn't appear to be, unless he is mistaken when he says at line 21, the standby is in relation to that person. And looking at it again, and we've all been through this so many times to try and reconstruct the position. I have to say it's not been the easiest thing to do. But at line 14, the court is saying this. This is on page 388. Let's just see if we can try and piece this together. The jury box is not so bad, says the judge. He says still no concerns, right. So he's obviously dealing with the jurors as he goes along the line. 18, none, 19, none, 20, yes. Mr. Mahoney says, stand by, sir. Now that can't be, on the face of it anyway, unless he's referring to the judge when he says, stand by, sir, rather than the juror, stand by, sir.
Which is possible.
Which is entirely possible, of course, because of Mr. Mahoney addresses the court in that way. Traditionally, he uses sir rather than my lord or such other expression. There's no criticism. I'm just saying that that's what he does. And I think that probably actually what's happening is when the juror has indicated an issue, because the judge says yes at line 20, he says, stand by, sir. And then the court says you might be recalled, point number 1, might be gone by Monday. Right. Point 1 may be gone by Monday. I have that little issue too, and mine is going, so that might be gone by Monday. Point 2 is more difficult. You have my sympathies as far as that is concerned. I wish the best for you, but it might not excuse you entirely. So you just take a seat now. I can only assume that there was a note written as is described in relation to Siobhan Hollis in Mr. Mahoney's schedule. And that we proceeded on the basis that that is as good a guess as anything. But it must be, to go back to that the standby, sir, is coming from Mr. Mahoney in relation to Siobhan Hollis, when an indication has been given. Now, she may have just handed up the note and he'd already read it.
And obviously the judge deals with points 1 and 2. Are you saying that Siobhan Hollis should be treated as a standby by virtue of Mr. Mahoney's comment?
It appears that way, and I simply put it as somewhat equivocal at this stage, because the judge has said stay where you are, basically, after having looked at it. He's not excused them. And so it must be that he is relying on Mr. Mahoney's standby declaration, because he hasn't gone on to consider the merits of the letter other than to make the observations that he does.
But he would not say, so you just take a seat now, if the Crown had in fact exercised its standby.
Well, he might have done, just stay where you are, because if we're now coming towards the end of the process, he's been going along the line to find jurors, and he may say, well, just wait there for the moment, because we may have to come back to you.
But that's
certainly not
otherwise.
I'm sorry?
That's not what happened with other potential jurors.
No, it isn't. No, it isn't. I make the observation only because we are now coming towards the end of the jury selection process for the 12 jurors. And he may have said, just stay there for the moment to see what happens. You'll appreciate at this stage, nothing's been read out about the witnesses. So we may lose a number of jurors simply because they get told which witnesses are to be called. Anyway, where we are is on that page. We then go to Ashley Lewis.
Well, just a moment. What are you saying in relation to Siobhan Hollis? Are you saying this is a Crown standby or not?
I say that it's equivocal. Certainly raises the spectre of it being a standby. And the best we're able to do by way of reconstruction from listening to the transcript and reading the material is that the person was being asked to stand by the Crown, perhaps for good reason. I simply don't know. But the judge had certainly not excused that juror at that stage.
So you say this is a Crown standby?
Technically, yes. I wouldn't want the case to turn on it.
Okay.
What I did on my schedule was to put a question mark next to it.
Yes. Right.
The next person is Ashley Lewis, and that's at on page 389 at line 9. The number 20 is called out, Ashley Lewis, and then of course say, okay, so we now have no concerns at red shirt and black dress, down the back line, none, down the front, no. Good, none. As that page comes to an end, and then prospective juror, I suffer from anxiety and depression, and I am absolutely panicked that I'll end up having a panic attack sitting here, says the juror. Mr. Mahoney says, stand by.
Ashley Lewis.
And the court says yes. And then number 10 is then read out. But so just pausing there for the moment, the person gives an explanation. Before that can be explored at all, Mr. Mahoney says stand by. So in our submission, that is a standby. It is unequivocal. And in our submission, it doesn't matter if an explanation is given because the judge has not excused this juror. In fact, before he says anything, Mr. Mahoney says stand by.
Do you accept that that was Ashley Lewis?
Yes. It appears to be the case. Having gone along the road, he comes back to that person.
So you say that's a Crown standby?
Yes, I do.
Right.
What's happening in our submission, what is happening is that the judge is not making a determination at all. And a juror might express a concern is not a bar to the person sitting as a juror. It doesn't behove the Crown to take that approach by saying stand by. We then go to page 390 because at 390 line right at the top, court having that person being stood by Mr. Mahoney, the court says yes. Number 10 is called, and that's Marion Darrell. Any concerns, Miss Darrell? Prospective juror, yes. And then Mr. Mahoney, before she can say any concern that she might have, she is stood by. And as I understand it, Mr. Mahoney doesn't dispute that that was one of his standbys.
And Mr. Lynch, just looking at line 8, when we're talking about Ms. Darrell, Mr. Mahoney says, stand by, sir, which would support the point that you were making before.
Thank you. Your eagle eye has got there before me. And yes, of course, he when addressing the court, he says, sir.
Yeah.
Yes. Right. And we know that's Marion. I'm assuming Marion in this case to be a lady. It can be used apparently as a
any concerns, Ms. Darrell. So
wasn't John Wayne's name Marion before he changed it to John Wayne? I got a feeling his name was Marion. Unsurprisingly, changed it to John. But there we are. I sort of side.
I'll look it up for Mr. Lynch.
Okay. Can I, before we pass on from that, can I invite your lordships to scroll down to page 390?
Lynch, I think Justice Smelly was saying something.
Yes.
I do forgive me.
Sorry, it's the problems at my end. The microphone seems intermittent. But I was making the observation that in respect of this juror, the Crown's note is that a note was handed up. Now, if indeed that was an exchange between Mr. Mahoney and the judge, does that not make a difference?
Let me just find where that is. Give me one moment, please.
The bottom of the second page of the Crown's note.
Yes.
Yes. I'm just trying to find that on the transcript. No, for some reason can't see it.
It's not apparent on the transcript that a note was handed up, but the Crown schedule asserts that.
I understand their schedule says that. I'm just trying to see if there's any reference to it at all on the transcript. And
what if indeed it happened and the judge considered it? Would that not make a difference?
Well, it depends. Two things. First of all, if there was a note, the judge could consider it and excuse someone off his own motion. If there was an issue that arose from a note, it should have come to council. We should see the note.
And you don't recall having seen a note?
Well, I don't know. I mean, I'm not saying it didn't happen. It could have been. I simply don't I simply don't recollect seeing a note at all. And I'm looking at it because what happened is the person's name is called by the court associate. Any concerns, Ms. Darrell? Yes. Stand by, sir, says Mr. Mahoney. Yes. And then moves on straight away to Caitlin Peniston. I don't recall hearing anything specific, and maybe Ms. Tucker can help me because I know she's listened to it rather more avidly. If there is anything there at all, if Mr. Mahoney says that he's heard something or that there's some additional material not on the transcript, then by all means tell us. But for my part, even if there is a note, I have no idea what it says.
May I say, sir?
Yes, please.
Yes, there's an actual recording of proceedings, and on Tuesday evening, Miss Tucker called us indicating that herself and Mr. Lynch don't have a copy of the recording. And so I understand why my learned friend may have difficulty with some aspects of the notes, because he has been proceeding on the transcript only, and they did not listen to the actual recording. In the actual recording, there is a 1 minute gap at 4:37, where the judge says concerns Miss Darrell. At 4:54, there's a rustle of the sound of paper, rustle of paper. Then the paper sound is heard again at 43:09 to 17. And then at 43:27.
Mr. Mahoney, you're going a little quickly for.
Oh, sorry.
You say there's a gap in relation to Ms. Darrow?
Yes, sir. If I'm not sure if Mr. Coelho will have the actual recording.
But I understood from what Mr. Lynch had said that either Mr. Lynch or Ms. Tucker had indeed listened to the transcript.
Ms. Tucker has, yes.
I did
No,
find. I did find the copy of the recording. This was after, because I did have a query regarding Miss Marion Darrow. So I called Miss.
So, Mr. Mahoney, where do you say that there's the gap? Ms. Darrow?
In listening to the recording,
Yes.
2:37, the judge concerns Miss Darrell.
Yes.
At 2:54, there's the sound of the rustling of paper. At 43:09, between 09 to 17.
So, hold on. I'm having.
Just a moment.
Yes, sir.
Really hopeless taking these things in. You say there is a gap at 2:37.
No, sir. 4:37 of the recording.
Well, you said 4:32. Wait a minute.
So,
Oh,
37.
sorry.
At 42:37,
Yes.
the judge says concerns Miss Darrell.
Yes.
Then at 42:54,
Wait a moment. The judge, the 42:37. The judge says concerns Miss Darrell. Right.
yes, sir.
Yes.
Any concerns, Miss Darrell? Yes. And then at 42:54, there's a sound of rustle of paper, as if there's paper being moved around in that sound.
And where is that in relation to what we can see on the?
No, sir, it's not reflected in the transcript. That's why in putting together our schedule, it was done using this transcript, our notes, plus the recording.
I'm not clear what you're trying to tell us. There's a gap of 17 seconds during which is heard the rustling of papers.
No, sir. I'm just indicating to you the era of the recording that if you listen to it, you will hear the following. So the recording is about an hour, 27 minutes, somewhere there. But if you have the opportunity to listen to the recording, I ask you to start at 42:37.
And what are we to infer from your statement that there's a 17-second gap?
No, it's not 17 seconds, sir. It's close to a minute.
What's the difference between 42:37? It's 42:37. I understood it to be minutes and seconds.
Yes, sir. But that's when the judge says, any concerns, Miss Darrell?
So what's the 42:54?
42:54 is when you'll hear the sound of paper coming over on the recording.
I see.
Yeah.
Then at 43:09 to 17, there's a further sound of paper.
43:09
to 17.
to 17.
Yes.
And this is all before the prospective juror says yes and you say stand by, sir.
Yes, sir. I said stand by at 43:27.
When?
43:27.
Not notes like these have been kept.
They should be kept, sir. I know that, well, once a note is handed up, it's shared between counsel. And in those situations, I would look at Mr. Lynch. Mr. Lynch would indicate by his facial expression or body language if there is any issue. If there is none, then I say stand by. If there's an issue, counsel will raise it with the judge. And notes are usually kept on file. I'm not sure what happened to the notes in this case.
You say it would have been shown to Mr. Lynch, do you?
Yes, sir. It would be passed to me, then passed to Mr. Lynch, then passed back to me. Then we would look at each other or communicate somehow. And then based on, the consensus, I say stand by. And that's the practice. If counsel have a difficulty with the note, then we address the judge on it.
If I can interject, yes, I did have difficulty locating a copy of the CD, so I did call Mr. Mahoney, as I did have a question about the note. Once Mr. Mahoney and Ms. Karen King Dean played it for me over the phone, they were telling me about the paper rustling, and I could not hear it. So we definitely did find our copy, and we have heard it now. And I can confirm that you do hear the paper rustling at the times that Mr. Mahoney has indicated, but it doesn't go more than hearing paper rustling.
It doesn't go more than
hearing the paper being moved around, like a paper rustling sound. So it's an assumption that a note was actually put forward at that time, but we don't know what the note says currently or said.
Yes. Thank you, Ms. Tucker, and thank you, Mr. Mahoney. Can I say straight away that certainly if a note had been handed up and shown to Mr. Mahoney, I would have seen it too, because I wouldn't have permitted it to have happened such that he would have seen it and not me. And there's no exchange of conversation at all that has been recorded. So I'm assuming that a note was handed up. He had a look at it. I had a look at it. I have no idea whether the judge did or not. And I don't think that Mr. Mahoney does either. So we simply don't know what's on the note, and we don't know what the position is. What we do know is that Mr. Mahoney took it upon himself to stand the juror by.
Just to record.
Well, you'll have your opportunity in a moment.
Okay, all right, fair enough.
It may be that it was a perfectly legitimate request by him that the juror should be stood down for cause. But once he says standby, that takes it out of the hands of the judge at that stage, and certainly takes it out of the defense hands. I don't know.
I'm not sure whether it's being said that you effectively consented to the standby.
Well, I suspect that Mr. Mahoney is going to say that. I can't tell you that.
Right.
I mean, I may have shrugged my shoulders. I simply don't know what's on the list. The person may have said something like, to take the kind of excuses that are often, it's very difficult for me because I have care of children in the morning, or something of that kind. I may have shrugged my shoulders. I may have done any number of facial tics.
The short answer is you don't have any recollection as to what was said.
I'm perfectly happy to say that, for the court to infer that a note was passed up, that if a note was passed up and Mr. McCarrington Mahoney saw it, I would have seen it as well.
But are you still asking us to treat this as a Crown standby?
I am, because it abrogates the judge's responsibility. What he's doing is to make the decision himself. That may be a legitimate decision to have been made, but it needed to be for cause, not for standby. And if we're talking about the appearance to the public, a note is passed to me and then he says standby.
Well, Mr. Lynch,
yes.
Having regard to your exchange earlier with Justice Bell as to what happened at lines 8 and 9, if Mr. Mahoney was there saying to the judge, stand by, sir, and the judge says yes, doesn't that answer your concerns about this particular matter?
No, because if Mr. Mahoney says to the judge, stand by, sir, he's taking the decision away from the judge.
Well, the judge says yes.
Well, I think he says yes because he's turning to the court associate to deal with the next juror. Because Mr. Mahoney has said stand by, sir, the judge turns yes, and then the next thing that happens is number 27 is called. I don't think the yes is assent to Mr. Mahoney. I think the yes is you've made the decision to stand that juror by. I don't have to decide anything at this stage. My decision will only come if that juror comes back again. I think it would be dangerous to assume the yes is an assent to what Mr. Mahoney is saying. So the jury has now been selected as far as we can see. And then comes this passage, which we invite you to consider, because Ms. Swan is asked to name those who are likely to be heard in evidence in the case. Names you are likely to hear in the matter, I should say, rather than in evidence. Names you are likely to hear in the matter, and they're read out. And you'll see then on the next page, 391, a long list of those that might be names that might be used in the case, which include onto the next page, page 392, at line 9, Rashid Mohammed. So there's a list of all the witnesses that are to be called to give evidence or whose evidence will be read that is of importance on page 391, and then on 392, after line 4, Dr. Brenda Davidson. The remaining, as I recall it, are all potential protagonists. And that includes Rashid Mohammed.
As opposed to witnesses.
Yes, as opposed to witnesses. We asked for those names to be added to the list because they were names of people that were going to be that we were going to raise during the course of the trial as persons of interest during the course of the trial. And it was obviously important that if there was a juror that had some connection with any of those persons, that they should make it known.
Right. So you say that Marion Darrell.
Yes.
Well, Marion Darrell is one of those whom the Crown accepted was a standby.
I thought so.
Well, that's what Mr. Mahoney said yesterday.
It is.
Right.
And so we say that in total, and I say it in total, the maximum that one might have identified from this selected group that make up the jury are 9.
Wait a moment. Wait a minute. The ones we've identified that you rely on so far are just a moment. Oh, wait a minute. Sorry, I've forgotten about yesterday's. They are juror number 8.
No, that's the Crown's first. We say the first one is Marilyn Cooper.
Oh, yes, I'm so sorry. Juror number 7.
Yes.
Juror number 8.
And that's conceded by the Crown.
Yes. Juror number 34.
Yes, and that's conceded by the Crown.
Yes. Juror number
29.
29.
Not conceded.
Sorry?
Not conceded.
Not conceded, I know. Juror number
3.
3. Juror number 32.
Conceded.
Conceded. Juror number, what did we get to next? 35.
Question mark.
Well,
No,
wait. No.
Yeah, that's number 7.
The
35 is done.
35 is what?
35 is one that we rely on.
Yes, quite.
In the sign. But I thought she was agreed to have been the 4 person. Sorry, it was Parsons. Right?
Yes, I don't think so, no.
So wait a minute, we've got to, you rely on numbers on Crystal Simmons, you rely on Linda Simons.
Yeah.
Quarry.
She's the one with.
She's the legal aid office lady.
Yeah, and she's the one that the judge said he wanted to try to hang on to, and so did I.
Yes.
That's number 7.
The 17 is on the turn. Siobhan Hollis.
Yes.
Then the next one is Ashley Lewis. You rely on that one.
Yes.
You rely on Marion Darrell, which is conceded by the Crown. So I see. So we get to 9 even without Siobhan Hollis.
President, I don't think Darrell is conceded by the Crown. Is she?
Oh no.
I thought she was.
Yes, that was what we were told.
Yes.
That was an error on the paper, sir.
Sorry?
That was an error on the paper.
Well, yesterday you said it.
Yesterday,
Or not conceded, Mr. Mahoney?
Yes, sir. I'm not conceding.
Not conceded.
Not conceded.
Right.
I see. I see. So you're withdrawing your concession yesterday, right?
I didn't have a, I know my Lord President referred to it. I didn't have a concession from yesterday.
I did, because I went through them all. Mr. Lynch put forward what he thought the Crown was conceding. Mr. Mahoney said he'd got that wrong. And he then told us that what they were actually conceding was 8, 34, 32, 10, 19, and 16. But it's now
Yes,
said.
sir, but, sorry. I'm sorry, sir.
Well, that is what you said yesterday, isn't it?
Yes, sir, because I was going by the email that my colleague sent. But on looking back at that with our chart, I'm not consenting, sir, but I'll address that.
Okay.
I thought it always been clear that they were conceding 6. That's certainly what we understood from them, and I was simply seeking to identify the 6. But is the position now that you're only conceding 5?
Mr. Lynch, I'll respond to you in fullness of time.
Well, it would be helpful to know.
It would be helpful to know now.
Very well, sir. The ones we are conceding are Charlene Simons, number 34.
Wait a moment. We concede 34, yes.
Yes, sir. Crystal Simmons, 32.
Right.
Tony Lee Curtis, that's number 8.
Yep.
Right.
Yes.
And over onto the alternates, Kenshanti Hippolyte.
Yes.
Yes.
19.
Yes, sir, that's 19. And number 16, Shanae Headlam Latham.
Yeah. Okay, so it's the ones you told us yesterday, but not number 10.
Yes, sir. That was an error on the part of my colleague.
Right.
So 5 are being conceded and only 3 from the original jury selected group. All right. Well, I'm not going to repeat what I said yesterday and today as to what we say the position is. We say it's 9. They now suggest that out of the jury group, it's only 3 that are conceded. I can see why that might be the case, but there we are. Can I turn, please, next to the alternates as they've been described?
Yes.
And I'm, of course, alive to the fact that these are persons who did not, in the end, serve on the jury at all. They were not required, but they are required as alternates. And to that extent, unless you wish me to do so, I don't propose to take the same amount of detail in going through them, other than to identify the fact that the Crown concede 2. We say, in fact, that on their own chart, there are 4. And can I take it relatively briefly in this way? That if you, 19 at the top of page 3 of the chart is conceded, so we need to dwell on that. The next one is a Dorianne Hurdle. And she, the Crown say, she was stood by. Nothing was said at the time, but works in the AG's chambers. Court smart recording say there is a discussion amongst counsel regarding this juror. Well, there may well have been a discussion about it, but can I say this, as far as we're concerned, the fact that the person worked in the AG's chambers is neither here nor there. The issue was taken out of our hands because the Crown stood this juror by. It doesn't matter what our view was. They had the power at that time to stand the juror by, and that is precisely what they did. Our position is, well, the fact that the person worked in the AG's chambers is an irrelevance. We're not being prosecuted by the AG. Anyway, that one we would submit. It is also a standby. Then the next one is Kyle Missick. And on that one, it's probably worth just looking 397, page 397 at line 7. Court Associate number 23, Kyle Missick. Any concerns, Mr. Missick? The only thing is I have travel on the 24th to the 29th of October. That might be a little close, says the judge.
Where is this? Where is this?
This is on page 397.
Oh yes, I see. Yes, I've got it.
397, and the dates being given there are the 24th to the 29th of October of 2018. And at that point, the judge is saying it might be a little close.
Right.
24th to the 20th, no, that's the following week. And so there was going to be a break. If we had to return, there was to be a break before returning. But in any event, that juror was stood down. I don't have any issue with that. David Cashin is the next.
Just a moment. You don't rely.
I don't rely. No.
Right.
Next one, defense exercised a challenge. No difficulty there. That's David Cashin. And then Sheena Headlam Latham, Crown standby. They concede that one. No issue there. And then the last one, Danielle Daniels. Crown stood that person by because the family, because the lady it said something about having a member of the family who'd been convicted of an offence. Again, I'm not sure that that was a genuine basis upon which to stand someone down. Your lordships will see what happened if you go to page 400. At line 13, Danielle Daniels is called. The court says, do you have any concerns, Miss Daniels? Line 17, Miss Daniels, I do have a question. If somebody in my immediate family has been convicted of, and then we can't hear what it says, would they have a conflict? And as well as knowing one of the witnesses or people that, and then Mr. Mahoney stand down. Well, I think again, I don't take particular issue with it other than to make the observation that no inquiry is made. The fact that somebody has a member of the family who's been convicted of an offence and or knowing one of the witnesses, it may not have been an issue, but no inquiry is made and Mr. Mahoney simply says stand down. How much further that takes this particular appeal, I'm not sure, but again, it's demonstrative of Mr. Mahoney taking the initiative rather than the judge on what is may well be a proper basis for someone to be excused, but we simply don't know.
Do you rely? Wait a minute. Do you rely on this one or not?
No.
You don't?
No. No.
Okay. Right. So what you rely on is 19, 18 and 16.
Yes.
Okay.
2 of which are conceded.
Yes.
And that takes us to the end of the process of identifying what we submit are the standbys. 9, if your lordships were to accept those submissions of our own. 3, if Mr. Mahoney is right and we've got it completely wrong, out of the jurors that actually sat. In your question 8 that you asked us to consider.
These are the ones who didn't sit.
Yes, everything that's on page 3 didn't serve as jurors.
Yes, but the ones who were stood by didn't serve as jurors either.
No.
No.
No, they didn't.
Yeah. Mm-hmm.
So I'm just trying to bring up your lordship's letter so that I can refer to question number 8. Here we are. No, that's the first letter. Yes, question number 8. The court would also welcome assistance as to whether if someone was stood by without a reason being given, there would be no substantial injustice if there was or may have been a good reason for removing or excusing him. The most obvious example, and you give the example as number 1 in our case, Marilyn Cooperdore, where a reason is apparently now given that she was known to the Crown working as an HR representative in the DPP's office at some stage. And so the point being made in your lordship's question is that the court is the most obvious example of that being that there's no injustice if there was a good reason. I've sought to address that in the course of these submissions by saying that it would be wrong for the court to retrospectively consider what the challenge for cause would be and whether that was a legitimate basis for doing so. And so in our submission, it's not an appropriate exercise to undertake because there are any number of factors that might play upon a judge's discretion to decide whether or not to admit a particular person to be excused or not. And in our submission, the fact that somebody, for example, and I've sought to do this where we've looked at a number of excuses that might be proffered now, but were not present then, as to whether or not they could, even if one were to undertake the exercise, whether that would be a legitimate basis. And in our submission, the vast majority where excuses are being proffered are not based on any real justification for it being excused, certainly not with any proper inquiry at any rate. And I appreciate that this is not a mini trial with each potential juror, but each juror's issue needs to be properly canvassed and the judge needs to entertain that. So if somebody has an issue, they need to express what that is. The judge can properly consider it and invite any representations from counsel. It may be that some of them would be conceded by the defences. Indeed, I sought to do on a number of occasions, once being slapped down for doing so. But it doesn't matter. The point is that the exercise was not being undertaken like that. Mr. Mahoney was simply saying stand by. And that was done repeatedly. And we say at least 9 times during the selection of the jury process as a whole, but a dozen times throughout the whole exercise.
Right. Well, now, what is the significance of the fact that 3 of these were alternates, if no alternate actually sat on the jury?
The significance in our submission is this, is that if a person is not, obviously they have no influence on the outcome of the jury's decision, but that's not the end of it, because the Crown seek, let's take the most extreme example, if the Crown are seeking to stack the jury in their favour, if that's the purpose behind it, and I don't say that here, I can't say that, I don't know what the purpose is here behind it, it's not the point. But if that were the case, selecting those using the same policy of challenge anyone that you don't fancy the look of, and putting them at standbys means that should there be a problem with the jury, you still maintain your connection, as it were, with those that you think are more likely to return a favourable verdict for you. So that selection process is a sort of stopgap, if you like, but it certainly provides further evidence to the well-informed observer that there is an attempt here to exercise a degree of bias, which, even if that person doesn't eventually sit on the jury, is indicative of that purpose behind it, and undermines the potential for a fair jury. Now, of course, if it just doesn't happen, it doesn't happen. But it certainly adds to the impression being created.
Well, yeah, okay. There's another point that you make. If you go to your responses to the questions posed by the court on the 15th of March,
Yes.
and you go to page
20.
No, 19.
19, right.
You deal with the alternate turnips, and you say this marks the end of the selection of the initial 12. The judge then indicates that he is minded to excuse any member who gave reasons which may make it inconvenient for them to sit, and select 5 alternatives with the view of replacing the 2 jurors and having 3 alternates. Can we identify who the 2 jurors were?
I think I need to go back to the transcript. Just a moment.
I can offer some assistance. The
Please.
2 jurors who the court were seeking to perhaps remove were Barbara D'Souza and Ronell Matthews. And they're on the first page of the schedule.
Well, that's what I thought.
Yes, the housekeeper who was extremely busy.
The psychologist.
And the psychologist, yes. Thank you. Is there a place, do you know, Ms. Tucker, where the judge dealt with that?
In the transcript at pages, well, page 26 of the hard copy transcript.
Right, well, that's page.
Sorry, it's D'Souza and who?
Ronell Matthews.
Oh, Ronell Matthews. Yes, I'm so sorry. Yes. Sorry, I interrupted you.
Yes, I'm just thinking.
Page 26 is 394 of the transcript in our bundle, but I'm not sure that's the right place.
No, I don't. One minute. Page 25. The judge explains his reasonings for selecting 5 alternates on that page.
Yes, near the top of the page.
Line 7, he starts.
We have to select 3 alternates, and there are 2 in the present rule, that the present group, that I would be sympathetic to if I have a replacement for them. And this lady who says she works for herself doing the maid duties, if it is possible to get enough to replace her, I would have no issue with that. And the psychologist over there who wants to do her programs, if there is enough, I would have no issue with that. But I'm not going to do it at the risk of running out of numbers. But if we can find enough, I would be prepared to do that. So we could do that 2 ways. If you are in agreement, we can try to select the alternates. And if we can get as much as 5, we can replace the 2. If there are no objections on either side, with 3 alternates. Well, there are, I think, 10 left who have not yet been, I think I was going to say called. Right there are 10, so we can try to go through these. Shall we do that first and then see whether you know? Yes, yes. See if it goes with that. So we're going to select from among the U3 alternates. We probably will try 5, and the purpose of these others that we're trying to select will be the alternates. It would listen to the evidence, and then he gives the explanation as to why they're choosing alternates. So if that does occur at the end of the trial and so on at line 16, and then the court associate starts to call out those names, starting with Kenshante Hippolyte, and that's when Mr. Mahoney says stand down, and then thereafter other names called, Karen Scott and so on. And I think we ended up with, this is the fastest. At the bottom of page 395, Mr. Alexander, I have business travel on the 29th. The judge says we'll be gone by then. Yep, this is the fastest court in the land. We have a good team. 14, Pamela Hall, number 5. Hold on a minute. Any concerns, Pamela? No, all right. Go for 5. David Cashin. We exercised a challenge. Dorini. I'm sorry, hold on a minute. And then I think we get to page 398. And that's at 398 is when he replaces one of the jurors, I believe. So if you go to the bottom of page 398, I think it might be more useful to start a little earlier on page 398, the court, line 2, all right, I'm inclined to seek to replace. Well, let's see if the defense has any objections to the alternates. Mr. Lynch, well, you'll be able to challenge those for cause, says the judge. Well, I can challenge though without cause. I don't propose to do that at the moment, but if your lordship is minded to replace the 2 ladies who were sympathetic toward, and there you see, I think that's not a prospective juror speaking. I think that's me.
Yes, sounds like it.
That's what I assumed.
Yes, and then the court, these 2, yeah, with the first 2 alternates, these 2. Yes, well, your lordship will need to do that first. Yes, that's quite fine. That's fine with you, Mr. Defendant. Mr. Smith-Williams says yes. Right, no challenge. All right. Madam, in seat number 2, who has to work for a living, you may stand down. Now, I understand that person to be Barbara D'Souza.
Oh.
Yes. That is seat 2. Let me look here first. Seat number 2, yes, Ms. D'Souza. I will call that judge 2, and you're replaced by A1, whoever that is. Karen Scott. 8. Psychologist in the seat number 12, you're stood down. That would be J3, seat number replaced by A2, you're replaced by Jackie Alexander. Good. Now, seat number 12, you've gone out. So, Camilla, you will become alternate number 1. David Cashin, you will be alternate number 2. And I think later we object to Mr. Cashin, yes. So 2 are replaced. The 2 that he was sympathetic to, they having given some reason why they wanted to be excused. He didn't stand them down immediately. They remained in place, but at the end, having identified that there were sufficient jurors to carry on with the process, replaced them. And that, I think, is the point that my Lord President was making, that we'd set out on paragraph 32 without actually identifying the passage. So forgive me for that.
If I can assist, I just wanted to indicate that one of the central points, in addition to what my learned senior has pointed out, is that the significance of the alternates was that Kashante Hippolyte, who was stood down without cause, would have been the person who replaced Barbara.
Yeah, sorry, I picked that up and I'm coming to that, if you'll forgive me interrupting. If we go back to paragraph 32 of your, Mr. Lynch's submission,
Yes.
you make that point. So just before we get there, 2 were replaced by alternates. And were there then 3 actual alternates?
I think I got a feeling we were left with 2 actually in the end.
Oh, okay. Right.
Because we challenged one, Mr. David Cashin.
Yes. Okay.
That was our challenge. And so we were left with 2 alternates, and that was regarded as sufficient.
Then what you say, which I think Ms. Tucker was about to observe in relation to Kenshanti Hyperlete, this was the first alternate selected, and upon confirmation that she had no concerns in sitting, the Crown stood by her. This is without cause, and it is accepted by the Crown they had no reason. Kenshanti is number 4 of the irrefutable standbys without cause. She would have replaced juror number 2, Mrs. Barbara D'Souza, identified on page 1 as juror number 12 on the Crown's schedule. And the point that I think you're making is that if you stand by / stand down an alternate who never sits as an alternate and would never graduate from alternate to panel member, then that's all rather irrelevant. But if what you do is to stand down without apparent justification, an alternate who, if you hadn't stood her down, would have gone on to the panel, that's in effect, you're in effect standing by somebody who would have been an actual juror.
Yes. I think that is certainly true, and that's certainly the point we're seeking to make. But we go a little bit further in the remaining alternates being challenged also, because our position is that whilst that applied on that particular occasion, the judge having replaced one of the existing jurors with this, what would have been the first alternate, the position would also be the same throughout the trial. If you select who it is that you want to sit as alternates using this process, you may have people sitting there as an alternate that takes that place by dint of some intervening event. Juror becomes sick, can't carry on, and so the person who takes over is the alternate that the Crown have left sitting as an alternate, having challenged others that would have taken their place. That's the point we're making. In addition. And the second person, who was Doreen Hurdle, she also would have been the replacement had the Crown not stood her by on the grounds that she was apparently working in the AG's chambers.
Right. Okay. Right. So in relation to these 2, the effect of standing them by was that they weren't available as they otherwise would have been to sit on the jury. Actually on the jury.
Actually on the jury, yes.
Actually on the jury. You say Dorian Hurdle would have been the second alternate after the reshuffling of the jury.
Yes.
Second after Pamela Hall. Haven't quite worked out how Pamela Hall fits into things.
I do think that this requires just a brief clarification. If I
right.
have the list of the alternates in the order they were selected, and I can supply that to the court once I type it up. But just so that the court has it, the first alternate was Kashante Hippolyte, who was polled. She was stood by. We obviously say that's of significance and of consequence to this cause. The next person called was Drake Simons. Drake Simons did not appear for the paneling, so he was not there.
You just wasn't there. Just don't, I'm afraid, don't take it quite so fast. You're imparting information that nobody's imparted to me before, and I do need to make a note of it. Drake Simons was the second alternative, and he didn't appear.
Right.
Top of page 395 for your lordship's note.
Yes.
The third, Karen Scott.
Yes.
The fourth was Jackie Alexander.
Just a moment. Yes. Yes.
The fifth was Pamela Hall.
Right, I see.
The sixth was David Cashin, who we ultimately objected to.
Mm-hmm.
The seventh was Dorian Ploder, who we list as second under Kashante, and we'll come back to that. The eighth was Kyle Mizik.
And the seventh was Dorian Hurdle, right?
Hurdle, yes. The eighth was Kyle Mizik.
Yes.
The ninth was Patrick Hayward.
Yep.
The 10th was Latham. On the list.
My Lord President, if I can just interject,
Yes.
stop at 10. It is now 11 o'clock.
Oh, right. We'll have to break off for the condolence ceremony. So, what?
On break.
Sorry?
I think she's going to produce a list for your lordship.
Well, that would certainly be
Type
helpful.
up. Yes, we'll get it done.
Okay, we'll rise now for the moment. Can we just go into a breakfast room, breakout room?
Yes.
How long is the break for?
I don't think that we know how long the break's for Kyrie and other appellants. I would, Victoria, do you know?
Sarah, it's going to be for about half an hour.
Okay.
It'll be about half an hour, chaps.
Good morning, everyone. This is the Court of Appeal for Bermuda sitting this 19th day of March 2021 at 11 o'clock in the forenoon for a special sitting to commemorate the Honorable Austin Ward, former Chief Justice of Bermuda and Justice of Appeal. This sitting is before my Lords, the Queen's Justices of Appeal, and we are joined by the Honorable Chief Justice of the Supreme Court, the Honorable Mr. Justice Narendra Hargan. My Lord President.
The court has convened this special sitting to commemorate the life of the Honourable Sir Austin Ward, who sadly passed away on the 22nd of February of this year, and to extend our heartfelt condolences to Lady Francesca Ward and his family. Sir Austin was widely regarded as a man with a keen legal mind, backed by underlying wisdom and a commitment to the rule of law, as was perhaps appropriate for a man whose initials were LAW. His family was at the core of his being, especially his daughters Desiree and Rosa, and his grandchildren Kyle and Kristen. Sir Austin came to Bermuda in 1969 from Barbados, and after starting in private practice, served in a number of judicial roles: magistrate, registrar of the Supreme Court, registrar of companies, solicitor general, puisne judge, and ultimately Chief Justice, a position in which he served with distinction from 1993 until 2004. Following his retirement as Chief Justice, he went on to serve as a Justice of Appeal for the Court of Appeal from 2004 till 2013. His award of a knighthood in Her Majesty the Queen's Birthday Honours List in 2006 was in well-deserved recognition for his services to Bermuda as Chief Justice. He prepared a compilation of Bermuda judgments, a task which had not previously been undertaken and which proved most valuable. He was well versed in the Latin tongue and given, I am told, to say grace in Latin at some length. He wrote poetry and published a book of poems. He was a soft-spoken man. Notwithstanding this, Sir Austin was described by some lawyers as being a formidable force and as a man who tolerated no nonsense. He was well loved and respected. Some lawyers, I am told, recall receiving lessons in court when on their feet giving submissions that did not entirely accord with Sir Austin's view of the law. He was respected by all sectors of the justice system, as well as by litigants who appeared before him. A consummate gentleman, he confidently walked the streets with briefcase and bow tie and administered justice without fear or favor. Bermuda has been enriched by his unmatched contribution to its legal system, which he served unwaveringly and with distinction. We express, as has Her Excellency the Governor, our profound gratitude to his family for his flagship service to Bermuda. He has left a legacy of fairness and integrity and an invaluable contribution to Bermuda's jurisprudence.
Thank you, my Lord President. I will now call upon the Chief Justice, Mr. Justice Hargan.
Believe muted.
You're muted, Mr. Justice Hargan.
I echo the remarks made by my Lord President. Sir Austin indeed made many contributions to the Bermuda legal system. His term as Chief Justice coincided with the development of international business in Bermuda, which in turn generated a number of precedent-setting cases. One of his many contributions was in the area of cross-border insolvency, particularly in the context of international restructuring of potentially insolvent enterprises, including this jurisdiction's approach to Chapter 11 proceedings in the US. In the seminal case of ICO Global in 1999, Sir Austin rejected the insular approach that Bermuda courts should always claim primacy in relation to a company incorporated in Bermuda, and that the courts should only appoint provisional liquidators for the sole purpose of winding up a company. This area has much developed over the years, but that seminal case has been the foundation of cross-border insolvency in Bermuda, where the Bermuda courts work in harmony with the courts of other jurisdictions, which have a legitimate interest in the insolvent estate, and the powers to appoint provisional liquidators are commonly used to facilitate restructuring as opposed to winding up. Sir Austin will always be remembered and admired, as remarked by Lord President, as a gentleman who was always polite, kind, and helpful in all his dealings with anyone he came in contact with. This included dealings with his opposite numbers, when he was in private practice with Mr. Arnold Francis QC in the 1970s, as Registrar of the Supreme Court, as Registrar of Companies, as Solicitor General advocating civil cases on behalf of the government, and of course, as a Judge of the Supreme Court and the Court of Appeal. We acknowledge with gratitude his 45 years of distinguished service to the people of Bermuda in the legal and judicial service. Sir Austin will always be remembered for his kindness and quiet manner to all those who appeared before him in court. Our thoughts and prayers are with his family in Bermuda and in Barbados. Thank you.
Thank you, Chief Justice. I'm now going to call on Mr. Alan Richards, who will be appearing on behalf of the Director for Public Prosecutions.
My Lord President, Mr. Chief Justice, Honourable Justices of Appeal and of the Supreme Court, ladies and gentlemen, I address this special sitting in the stead of the Director of Public Prosecutions, Miss Cindy Clark, who unfortunately is unable to be with us at short notice this morning. And I have been asked by her to extend her apologies because she had very much wished to be present this morning, and to extend on her behalf the condolences of her and the whole office to Lady Francisca Ward, the family and friends and colleagues of the late Sir Austin Ward. Miss Clark was called to the bar at a time when this distinguished jurist was serving as the Chief Justice of Bermuda, and she remembers him fondly. I myself, regrettably as a recent import to this jurisdiction, did not ever have the privilege of appearing before Sir Austin. But Ms. Clark remembers him as a kind but firm jurist who, of course, was fair. And she recalls in particular an appearance that she made opposite the now president of the Bermuda Bar, Ms. Christopher, in an appeal to the Supreme Court that was heard by Sir Austin. Unfortunately and regrettably, it appears that on this occasion, neither Ms. Christopher nor Ms. Clark had filed any written submissions with the court in advance of the hearing, a situation which I am sure would not arise today. Sir Austin addressed Ms. Christopher on the lack of her submissions, and she informed him that she had simply been too busy to prepare any. He gave her a telling off, but it was as nothing as to the telling off that followed when he turned his attention to Ms. Clark and asked her why she had not filed any submissions with the court. Ms. Clark thought that the fact that the appellant had not filed any submissions might cause Sir Austin to go easy on her, but no. Sir Austin gave her a thorough telling off and reminded her that her duties to the court have absolutely nothing whatsoever to do with the appellant. And Ms. Clark informs me that since that hearing, she has never again been late in filing her submissions with the court. So she remembers Sir Austin fondly, and it's clear from everything that I have read about this distinguished jurist that he has been very important in the formation of so many of Bermuda's greatest practitioners and other judges. And so with those remarks, my Lord President and Mr. Chief Justice, thank you very much for the opportunity to address the special sitting.
Thank you, Mr. Richards. I'm now going to call on Miss Elizabeth Christopher, President of the Bermuda Bar Council.
Okay, so it's really interesting that I have to follow that address. But I did wish to say that it is with great sadness that we in the bar mourn the death of Sir Austin Ward, for so long a pillar of our community and an example to us all. Although I do not understand him to be a person of humble beginnings, and for many lawyers at the bar, the fact that I think his family used to own Montgay was his real true claim to fame for some. But from our vantage point in the bar, he lived a life of quiet and humble service in our community for most, if not all, of his professional life. As the situation permitted, he was either a man of wit and quiet mischief or a concise and reflective jurist. Sometimes, whether professionally or socially, he was all of those things. Although he left Bermuda to return to Barbados some time ago, we still feel his loss as we did then, but we are thankfully reminded by his writings and his judgment. I would just like to convey to my fellow members of the bar and to my Lords Justices of Appeal and the other judges and jurists present that we view this occasion with great sadness. Thank you.
Thank you, Ms. Christopher. I'm now going to call on Mr. Mark Pettingale, former Attorney General of Bermuda.
Please, my lords. My lords, I had the distinct honor of being called to the Bar of Bermuda in 1991 by Sir Austin. And I think that he always perhaps had a special consideration for those people that he called to the bar and kept an eye on them. Where I certainly was fortunate enough over the years to do many, many cases in the Supreme Court in front of Sir Austin. He was always such a gentleman, always polite, always extremely patient, which must have been a very special challenge with someone like myself appearing so often. And I learned so much from him, certainly more Latin than I ever did during my school days. My lords, I recall one occasion where the clerk came out during a hearing and said that the Sir Austin wanted to have a word with me. And I remember thinking at the time, what have I done now, as it usually would be the case of some trouble or mischief. And I thought, no, that's not the case on this occasion. He wants to see me, and perhaps he's seeking my erudite view or advice on something. So I skipped back into his chambers where he was, and in his usual polite manner, he said, please, have a seat, Mr. Pettingale. And he then proceeded to say, I was listening to you during your submission this morning, and I thought, oh, here he wants to have my legal view on something. And he said, and I noticed how immaculate you get your goatee, and I'm wondering if perhaps you could give me some advice on how I can get my beard shaped like that. That was the only advice he ever asked me for, my lords. But I recall it funny. He was certainly a man who knew how much his family meant to him. I remember on the birth of my eldest son, when he was just a young boy in arms, taking him across the street to see Sir Austin, and his very sincere reaction to the birth of my first child. And all he kept saying was wonderful, wonderful, wonderful. And it was just a reflection of this quiet, humble giant of a man with a fantastic heart. I certainly will recall him fondly always, and endeavor to carry all of the lessons that I learned from him during those years, particularly that of patience and to always be seeking wisdom. My lord, I extend my sincere condolences to Lady Ward and all of his family.
Thank you, Mr. Pettingale. My Lord President, with your leave, I have three correspondences to read into the record. One from Her Excellency the Governor, one from Sir Anthony Evans, former Justice of Appeal, and one from Mr. Archibald Warner, former senior magistrate of Bermuda. Her Excellency the Governor, Ms. Raina Lauji, writes, Dear Sir Christopher, on behalf of myself and my predecessors, I would like to record my gratitude for Sir Austin Ward's contribution to the field of law in Bermuda. After starting out in private practice, Sir Austin made the move to the bench in 1972, first as a magistrate, then Registrar of the Supreme Court and Court of Appeal, Solicitor General, puisne judge, and finally as Chief Justice. Upon his retirement as Chief Justice, Sir Austin then served as a member of Bermuda's Court of Appeal from 2004 until 2013. Bermuda's reputation as a first-class legal jurisdiction is due in no small part to the excellence of its judiciary. From all I have heard, Sir Austin brought to the Supreme Court and the Court of Appeal not only much experience, but also a keen legal mind backed by underlying wisdom and a strong commitment to the law. His award of a Knight Bachelor in Her Majesty the Queen's Birthday Honors List in 2006 was in deserved recognition for his service to Bermuda as Chief Justice between 1993 and 2004. In addition to his service in Bermuda, I know that Sir Austin also served with distinction in his native Barbados. I offer my condolences to his wife and family on their loss. Sir Anthony Evans, I am greatly saddened to hear that Sir Austin Ward has died. I liked and admired him enormously, and sitting with him and Sir Edward Zacher as president in the Court of Appeal was a highlight of my career. It was also a happy experience, and Austin made a huge contribution in every kind of case. He had a gift or instinct for the correct answer on questions of fact and law, and his firsthand knowledge of Bermuda and its community was invaluable. I have missed seeing him since we both retired at about the same time. With my regards to you, President, and my deep sympathy to Lady Austin and her family. And finally, from Mr. Warner, it is with sadness that I salute the late Sir Austin Ward. Sir Austin's legal achievements and contributions to Bermuda have been spoken of. In any event, they speak for themselves. I have known Sir Austin since around 1960 as a 12-year-old boy at Christ Church Foundation School, Barbados, where he taught me Latin, I think. We again connected in 1972 when he arrived in Bermuda to begin his legal career. On Sir Austin's attaining the post of Solicitor General in Bermuda, I, having qualified as an attorney at law, joined the Attorney General's chambers, which superintended the Solicitor General's chambers. At the Attorney General's chambers, Sir Austin was my pupil master and legal mentor. Our careers and advancement continued, mine substantially behind his in many ways. Our legal adversarial system brought us to the usual legal tension between bench and bar as I practiced criminal defense law with Sir Austin on the bench at various levels. However, his enduring quality consistently shone through that of fairness. His fairness and charity was also evident off the bench, where he often quietly assisted with many Barbadians, West Indian, and persons generally who failed to navigate the social, legal, and racial difficulties that Bermuda presented. He was a quiet, conservative man who did things quietly but got things done. He was a little man in stature, but a quote-unquote big man. He is a great loss to the Bermuda legal community and system. He will be missed. I have already conveyed my condolences to Lady Ward, daughters Rosa and Desiree, but once again, my heartfelt condolences to his family. May he rest in peace.
Thank you very much, Mr. Coelho. I will now bring this session to an end. But before I do so, I have to announce with a heavy heart that Lady Kay, the wife of Justice of Appeal Kay, died earlier this week peacefully at home in the company of her family. For those of us who had the joy of knowing her, it is a sad loss. She loved Bermuda, and we shall be sorry not to see her in the place that she loved again. I would like to express our condolences to Sir Maurice and to all his family. With that, I will bring this session to an end. Thank you all very much for attending.
Court now adjourns and will reconstitute. Right, good morning, everyone. We are approaching 11:30 and we had two judgments to hand down. I see that the parties here for the case of Pedro are present. My Lord President, if you wish to proceed with that one first. I see Mr. Horseman also for the De Silva case, but I don't see Mr. McCoskey.
I'd just like to adjourn for a moment. Can we go to a breakout room?
Yes. Right, good morning, everyone. We have reconstituted. The court will now hand down the judgment in Civil Appeal Number 1 of 2020, Wanda and Pedro against the Attorney General and Minister for Legal Affairs.
For the reasons which are contained in the judgment that we now hand down, the appeal must be dismissed. At the end of our judgment, we observe that since the appellant has been legally aided throughout the proceedings of the appeal, we have it in mind that there should be no order as to costs, and subject to any submissions to the contrary, which should be filed within 14 days of the publication of this judgment.
Thank you, my lord.
Thank you, my lords.
Right, the court will now call Civil Appeal Number 12 of 2020, De Silva against Gibbons and Hirana for handing down of judgment.
The reasons contained in the judgment which I now hand down, we dismiss the applications for leave to appeal and for an extension of time. In the absence of any application in relation to costs, which is to be made within 21 days, we propose to order that the respondent should have their costs of this appeal.
Thank you, my lords.
Thank you. Right. Those are the two judgments that the court will be handing down today. Thank you for those parties who are not involved in the next proceedings, which is the Roberts, Brangman, and Smith-Williams appeal. Ms. Pedro, I see that you've joined us late. Your counsel will be able to advise you on the result of the appeal. Okay, thank you, everyone. If you have no further business with the court, you may leave.
Mr. Coelho, I'm sorry. I was just informed by a colleague that I should join, but I don't know whether, and so I have done so, but I don't know whether you did actually need me or not.
Personally, I don't.
Very nice to see you, Mr. Richards, but I don't think I need you.
Very nice to see you too, my lords, but I'm inferring that I wasn't involved in either of the matters in which you have just delivered judgment, so I shall.
That's what I understand. Yep.
Thank you so much.
Yeah, see you again later.
Thank you. Bye-bye.
Thank you.
Right.
So, Christopher, did you want to go into a breakout room, or are you happy to proceed?
I'm happy to proceed.
Okay.
Now, we were discussing alternates. Oh, wait a minute. Have we got? Oh, we have. Yes.
Yeah, I just noticed Mr. Pettingale is not. He's coming back into the call now.
Oh, right. Okay.
Okay. We're ready, my Lord President.
Yes. Ms. Tucker, you were addressing us.
Yes, my Lord President. I have, during the brief intermission, been able to forward a copy of my poorly crafted schedule, but it does reflect the alternate schedule on behalf of Kyrie Smith-Williams, the filter down or the round by round process that left us with two remaining alternates, despite the court's desire for three.
Have we got that?
I've emailed it to the group.
Have we got that?
Mr. Clelo,
What time did you send it? I see it. I see it. Okay. All right, it's just been sent.
Seems to be taking some time to cross the Atlantic. You have sent it, have you, Claire?
I have. Do you have it, Justice Smelly? You're in the Caribbean seas.
I could share it on screen if anybody wants me to do that.
Well, I'd much prefer to have it.
Sure.
Do you have it in your inbox, Justice Bell?
I do not yet.
Showing a sent.
Sorry?
It's showing a sent.
There must be an issue if it still hasn't arrived at
Yeah,
any location.
I still don't see it.
Yeah, there must be an issue. Could I temporarily at least put it shared screen so that we can actually proceed and
okay.
Mr. Coelho could then perhaps make sure that everybody gets a copy of it.
Okay.
Oh, what's
Coelho,
happening?
Coelho, will you share the screen? Yes.
I'm sorry, Mr. Lynch, what are you requiring me to do?
You need to allow me to share the screen because you have control of it. So unless you allow me to do it, it's up and ready to go. So.
All right. Mr. Lynch, I've just been handed a hard copy, even though I have not yet received the email, but I have the hard copy now.
Well, Mr. Lynch, what I'll do for the time being is make you the host so that you could share the screen because I don't know how to.
All right, thank you.
Don't seem to be having much luck.
No, you haven't done it yet, Mr. Coelho.
I have. You are now the host.
Not allowing me to do it.
Oh, no.
You may have to try it again as the host. I think when you tried it, you were just a participant in the call.
Just done that. It's not letting me do it. While you the document, perhaps you'll take over the hosting again and you can put it up.
Okay, you'll send it to me.
Mr. Coelho, your email arrived, so perhaps it got to my fellow judges as well.
Yes, the schedule has just arrived.
Oh,
Good.
So that solves that problem.
Mr. Lynch, could you return the host to me, please? I like to be in control.
I bet, and I'm not sure I know how to do that. Just one moment.
Right. Well, Ms. Tucker, thank you for this, which is very helpful. But can I just work out what we get from it? The position, as I understand it, is that Miss Hyperlite was stood by. If she hadn't been stood by, it would have been she who replaced Barbara D'Souza. That's item number one. That's right. Can you speak?
Yes, that's absolutely correct.
Right.
Yes.
The next one called was Drake Simons, who didn't appear. Then Karen Scott was called, and she in fact replaced Barbara D'Souza. And presumably, if Karen Scott had not replaced Barbara D'Souza, but Keshonte Hyperlite had, Karen Scott would have replaced Ronelle Matthews.
That's absolutely correct, yes.
Right, just a moment. So the effect of that was that standing Keshont Hyperlite out removed somebody who would otherwise have been actually on the jury.
Yes.
Yes, ma'am.
Which you say is the equivalent of standing somebody by first time round.
Has the same effect, yes.
It's the same effect. Okay. Well, that's all we need from this, isn't it?
I think so, yes.
Sorry if I sound a little slow, but
okay. No, not at all. I'm having some difficulty handing control back to Mr. Coelho. I'm not entirely sure, but for the moment, I shan't touch anything. So
if you put the mouse over my video, you should see a blue box that has 3 dots in it.
Yes.
You click that blue box with the 3 dots and it should say make host.
Done.
Okay. Yeah. Okay, thank you.
Excellent. Thank you very much. And that, I think, brings us pretty much to the conclusion of our submissions on these individual standbys. And your lordship will see that there is obviously now an even starker difference between what Mr. Mahoney says is the position and what we say the position is. We say that in total, some 12 jurors were stood by, and he concedes but 5.
Right. Okay. I may have some more general questions in a moment, but let's hear from Mr. Mahoney, if we may, if that would be convenient. Yes.
Morning, sir.
Morning.
Yes, sir. Just before, I just want to clear up something that council made reference to very quickly. And council indicated that when the list of names were called out to the jury, that the name Rashid Mohammed and the other names to the end of the list were what he gave to us. That is not so, sir. The names are what we refer to as likely to hear in this matter. And part of the Crown's case was that Rashid Mohammed's name would have been mentioned, as well as the other names that followed, and also reference to the MOB gang.
Sorry, when you say you refer to them as people likely, you said
Yes.
likely to hear. What do you mean likely to give evidence or likely to be referred to in the evidence?
Names that they would likely to hear in the matter. In other words, some were witnesses and some were names that they may hear coming out of the evidence.
Okay. Right.
On that point, sir, I did ask Mr. Coelho to see if he could recover the court smart recording of when Mr. Lynch replied to the Crown submission in the last appeal. And on that occasion, Mr. Lynch acknowledged and actually gave an explanation why Mohammed's name was not given to us as a possible witness. I think I read this before in my submissions. And he said, we did not name Mohammed at the outset of the trial as our witness because we did not know to what extent he would be required.
Right. That's what you told me.
Sorry, sir.
That's what you told me yesterday, I think. Or at some
Yes,
stage.
sir. And Mr. Lynch acknowledged that he did say that.
Just a moment. Sorry, I'm going back to my note. The note that I made was that, well, the note that I made was that you said, counsel said there was no intention to call him, but when you cited what he actually said, you said that Mr. Lynch said we did not name him because we did not know the extent to which he would be required. If Harris's evidence was sufficiently undermined, we would not need to call him. That's the note I made. Is that right?
Yes, sir. He started out by saying we did not name him at the outset of the trial as our witness.
Yes.
Right.
That's correct.
Yes, he acknowledged that he said that. So it's a bit curious at this juncture. He's now suggesting that he actually gave us Mohammed's name along with other names to call at the start of the trial.
Right. Well, the evidence, as I say, I have noted that Mr. Lynch said, and it is accepted, we did not name him at the outset of the trial because we did not know the extent to which he would be required. If Harris was sufficiently, evidence was sufficiently undermined, we would not need to call him. And that, as I understand it, tell me if I'm wrong, is agreed.
It's agreed, certainly by me.
Agreed, sir.
Okay, thank you. That's helpful.
I will start with Ms. Marlene Cooper, sir.
Yes.
And it's our submission, sir, that this juror was stood by the Crown.
Just a moment. Yes.
And she was a juror who would or could have been excused? From the case? In any event, sir, notwithstanding the fact that the reason why she was stood down was not shared with the defense and the court at that time.
Mm. Right.
Ms. Cooper-Dore, as HR representative for the department, someone who worked closely with members of this department, including myself.
Sorry, with the members of which department?
The Department of Public Prosecution.
Oh, I see. I follow. Right.
And had her name called up the second time and we had to go for cause would have been established.
What do you say, Mr. Mahoney, to the fact that by reason of a simple standby having been said as soon as Mr. Cooper-Dore's name was called, that gives rise to the appearance?
Appearance of?
In relation to the formation of the jury.
Well, my lord, that's why yesterday I did make the submission that myself does not necessarily give the appearance of bias, because there is also a presumption that a person using the informed reasonable observer test, the informed reasonable observer knowing the employment connection.
Well, hang on. You can't assume that the reasonable observer knows the employment connection. You haven't said anything about it.
Yes, sir. However, had the witness been called the second time around, had the juror been called the second time around?
Yes, but that's a hypothetical.
Yes, sir.
The juror was not called a second time around. So there's nothing that the reasonably well-informed observer would note, because he wasn't informed on these matters that you're referring to.
Sir, the process, sir, is that I understand what the court is asking, sir, and it is my submission, sir, that looking at it from a realistic perspective, sir, had the juror's name been called the second time around, sir, and we had to go for cause, she was someone who was not likely to be sitting on the panel.
Well, but you say, had she been called a second time around?
Yes, sir.
But so far as anybody observing the process is concerned, there's no difference between the position of Marilyn Cooper-Dore and the position of Tony Lee Curtis, where, I mean, in both instances, as soon as the name is called, you say standby. So for the observer in the courtroom, there's no difference between the two whatsoever.
Very well, sir. We'll give them that. I will concede for now on that point. For now, I'll come back round to it. But for now, I'll give that number to the appellant.
Right.
Okay. Right. Okay.
The next one I think of contention is Maria Rewan.
Is who?
Miss Rewan.
Juror 28.
Yes, sir.
Sorry, 29.
You see, this is a difficulty we have now, sir, because in respect of Miss Rewan was a former accounts clerk in the Supreme Court. Her office was located in proximity to the office of Justice Greaves, and they had a close working relationship, I understand. So she was familiar with the judge and so on, sir. That was not announced in court, sir.
So it's the same sort of situation as Coupador. There was a good reason, it just wasn't shared at the time.
Yes, sir.
I mean, as is apparent from this discussion, the potential problem that faces you is that a jury may be in fact biased, or it may have the appearance of bias. Both of them prima facie mean that there's no fair trial, as a result of which we are crawling through a whole list of witnesses. One possibility, which will be thoroughly objected to by the appellants, is that in a case of retroactivity, an appearance of bias or a want of equality of arms is not a sufficient substantial miscarriage of justice to justify setting the conviction aside, having regard to the public interest in the finality of what may be a large amount of criminal litigation. But I'm sure the submission will be that that proposition is heretical. But if one is bound to consider apparent bias, one has to look at the position as it presented itself at the time to the putative informed observer sitting at the back of the court. And the question is even more complicated because the fact that a possible juror is kept off the jury could be said not of itself to show that those who were actually on the jury were biased. The question is whether the fair-minded observer would think there was a danger that a jury selected in the manner in which it was selected was biased in favor of the Crown, compared with what it would have been if it had been selected in a different manner. These bias cases, they normally concern a single judge, and the single judge sits, or more than one, or three judges sit. But here we're concerned with what is said to be the apparent bias in leaving out those who might have sat. It's just an additional complication. But if apparent bias is sufficient, you may have problems.
Well, my lord, there is a difficulty as well because apparent bias in which direction? I asked that rhetorical question because if we did not stand by these persons and they actually sat on the panel, then the appellant would be arguing that we should have exercised our right to stand by those persons, rather than allowing them to go on the panel.
But I think the difficulty of that proposition, Mr. Mahoney, is that you're now talking about a challenge for cause. And you had perceived a basis for that in these two cases, but you didn't express that as a reason for standing what would have been a stand down.
That is so, sir. However, at the time, there was no requirement for us to give a reason. If there was a requirement to give a reason when we stand by, it would have been done. Hence my submission on either yesterday or earlier this week that in effect it is applying the law retrospectively to a situation where at the time what was done was perfect and in keeping with the law and practice. And we submit that to require us to have to give an explanation when previously none was required would be unfair in the circumstances.
So you say these particular issues should be judged according to whether or not you in fact had cause, even though these are expressed to be standbys.
I'm sorry, so I didn't hear the last part of what you said.
Yes, in effect, you are saying we should have regard to these on the basis that you in fact had cause, even though they are on the record as standbys.
Yes, sir.
And that the putative informed observer would be taken to have had understanding of that. On what basis?
Well, sir, during the process of the jury selection, sir, the putative observer would be sitting there and would be also observing body language of prospective jurors as well as what's happening in the court. The transcript does not necessarily reflect all the dynamics that actually occurred when the jury selection process was happening. And that's a difficulty that we have. That's why there is some air of challenge between counsel and myself as to what exactly happened. So if the putative observer was sitting there, they would be attuned to the dynamics of what was happening at the time.
Mr. Mahoney, I simply
Yes, sir.
I don't understand that, and I have difficulty accepting it. There's no difference for the observer between Marilyn Cooper-Dore, to whom you immediately say stand by, which you say is not properly a standby because there was a good reason that just wasn't shared in the public forum at the time, and Tony Lee Curtis on the next page, where you also immediately say stand down, meaning stand by, and you concede that it's a standby. The informed observer can't see any distinction between the two.
May I just give an illustration, sir?
Certainly.
Yes.
I wouldn't mind you answering my question first as to perhaps you're doing that with your observation as to why there is any difference between the two.
Well, sir, I could just give an example, sir. And just an example. Let's say, for example, the observer is sitting there and Ms. Cooper-Dore came in, looked at me and smiled, and I said, stand by. There's a completely different dynamics as to what's happening, which is not captured in the transcript.
Well, I don't know whether that hypothetical which you're giving is actually something that happened.
Well, that's the problem, my lord. Many years after, I'm now required to give an explanation, which at the time I was not required. If at the time I was required to do so, an explanation would have been provided. But I do know that Ms. Cooper-Dore is someone that I work closely with in her HR capacity.
Very well.
I can only give an account for those the persons who I knew, sir. In respect of next one, I think council now take issue is Keith Bridges. And I find it a bit curious that in council submissions, his name does not appear as one in which he took issue. Actually, in his submissions, the names that he took issues with were Marilyn Coupador at page 16 of his submission, sir. Well, actually, his responses to the questions posed by the Court of Appeal on the 15th of March 2021. It's a document, sir. For March 2021, second session at page 16.
I'm so sorry, what documents are we looking at?
This is a document that Mr. Lynch sent responses to questions posed by the Court of Appeal, 15 March 2021.
And I can't locate that at the moment, so what does it say?
Well, in respect of, at paragraph 31, Mr. Lynch made a list of the jurors that he had issues with. And he says, if we look at the jurors stood by without cause, the appellant submits the following on each.
Mr. Mahoney, I observed that Keith Bridges' name is not on that list.
That is what I'm pointing out, sir. I'm just going to quickly indicate the names that he included on that list and the names that he included on this letter dated the 26th of February 2021, which we got into this week.
That list either.
Is not on that list as well, sir. And that's why I find it a bit curious that only this morning we're hearing that there's an issue with some of these additional names. So in regards to his written submissions, responding to the questions, the names he had were Marilyn Coupador, Tony Lee Curtis, Charlene Simons, Maria V1, Crystal Simmons, Linda Simons, and Marion Darrell. And then he went to the three alternatives, well, the four alternates. Those names were referred to: Kashante Hippolyte, Dorian Hurdle, Shanae Headlam Latham, and Daniel Daniels. When we came to the more recent document, some addition, of which Keith Burgess was never included in any of those documents.
But Mr. Lynch's case, as he presented it to us this morning, was that Bridges should be treated as a standby because the travel commitments were irrelevant in view of the fact that the judge had said that he wasn't sitting that week.
My lord,
and,
sorry.
Yes, sorry?
I'm sorry, go ahead, sir. I thought you were finished.
And the second one being that the job commitments weren't investigated and shouldn't have any relevance. Everybody had job commitments.
Well, my lord, my submission is that Mr. Lynch can say that now, but in a situation where the prospective juror raise an issue, the general practice is we would look at each other and based on the body language or whether he has sent or what have you, then I would say stand by. Mr. Lynch is now saying that the dates were irrelevant. Yet, in regards to Kyle Messick, he conceded—
In regard to travel?
Yes, Mr. Messick was another travel from the 24th to the 29th of October.
Right.
And Mr. Lynch indicated that he had no issue with that particular stand-down or standby. So that was proper. Yet, in respect of Bridges—
But hold on. The point about Mr. Mizik is that his travel dates went into the week that the judge said was going to be operative.
Yes, my lord. But my lord, what I'm trying to establish is that at the time when we were in court, travel dates to the end of the month were seen as possible problems because there was no certainty that the case would have finished or reached at a particular stage on particular dates.
Right. Whereas in the case of Mr. Bridges, his travel was only the 22nd to the 24th, on which dates the court would not have been sitting in any event.
Sir, my understanding, sir, and based on my notes, the agreed position was that since it was likely that the trial may go into that period and to avoid any problem, that's why those dates were being frowned on.
Don't understand you. We're maybe at cross purposes. In the transcript at page 4, the judge says, we hope to be finished by the 22nd, but if we're not able to do that, we'll have a break for the rest of the week and we'll complete it the following week. Mr. Bridges' dates for travel were 22nd to the 24th, i.e. the week that the judge has excluded. Unlike Mr. Bridges, Mr. Missick's date went into the following week, which is why Mr. Lynch said that was on the wrong side of risky. That's the way I understood it.
Sir, I heard what you have said, sir, but it is my submission that we were particularly careful when it came to those dates, sir, because from experience, trials for one reason or the other can last much longer than anticipated.
I'm sorry, I must be at cross purposes with you. Are we agreed that the dates that Bridges was going to be traveling for are dates when the judge has already indicated he is not going to be sitting?
Yes, sir.
Right. And in Missick, the dates when he says he's going to be traveling include the week starting the 29th, when the judge is expecting to be sitting.
Yes, sir.
So they're different?
Not necessarily, sir.
Oh, why not?
There are certain aspects, sir. When we're impaneling the jury, we're looking at one, the availability, and also a second aspect is a judge, not a judge, is a juror willing to serve? This was someone who was actually on the panel, and when the court was going through to find out if there's any difficulties, this was someone who volunteered information which would suggest he was having a difficulty in wanting to serve on the panel because he had other concerns.
Mr. Bridges we're talking about.
Bridges, yes, sir.
Yeah, and he had two different concerns. One related to his full commitment, and the second related to his travel dates.
Yes, sir.
Mr. Lynch's submission, which I understand, is that the travel dates are irrelevant because the judge has already indicated he's not sitting that week.
Yes, sir, but he also indicated issues with job commitments. And one will recall when going through this transcript, there are jurors who had issues with their jobs.
Right. The only point that I was trying to make, Mr. Mahoney, which I think you agree with me now, is that Mr. Bridges' travel dates were irrelevant.
Yes, sir, but well, there are two
aspects
to his concern.
Yeah. I think we're now on the same page.
Yes, sir. Thank you.
Essentially, what you're saying about Mr. Bridges, that the putative informed observer would not have been concerned at him being stood by.
That is so, sir. Because clearly his attention would be elsewhere, rather than being focused on the case. We next come to Miss Linda Simons. In respect of Miss Linda Simons, she's at page 18. Miss Linda Simons has been the office manager for the Attorney General Chambers for well over, well, from I arrived here, which is over 16 years ago. And from time to time, she assists us in, as being as our office manager, and has had interactions with members of this department.
So wait a minute.
Yes, sir.
She had been an office manager where? In the Attorney General's?
The Attorney General's Chambers, but because we are under the same ministry, from time to time over the years, she has deputized or assisted us as office manager.
But she has assisted who?
She has assisted us over the years as office manager.
Who is us?
At the Department of Public Prosecutions.
Right.
We're actually in the same building. We're on the second floor. She's on the fourth floor. And therefore, someone we would interact with on almost on a weekly basis in the elevator and so forth. So although I did not disclose that, there was no way she could sit on the panel.
Right, but she's effectively in the same position as Coupador, isn't she?
Yes, sir. And she actually raised a concern when she was going along the line.
No, what the concern that she raised was simply these words: I've been seconded to legal aid officer. Legal aid is in an entirely different building, and the court says yes, prosecutor. She says, I'm sure that. You say stand by.
Yes, sir, but it's at the invitation of the judge. It just says yes, prosecutor.
But no, it's not at the invitation of the judge. The judge is asking you what you're going to do. But I don't see the difference between Coupador and Simons.
My lord, if one listened to the actual recording, the judge was actually, I took it as an invitation from the judge.
You say that the way that the judge said, yes, prosecutor, was an invitation to you.
Yes, sir. And at the time, I did not know exactly, and as someone in the legal aid department is a different building, but the legal aid department would also come in contact with litigants, defendants, their families, and so forth. Mr. Lynch said his client was not legal aided. We would know that because from time to time, legal aid do retain counsel for defendants.
Right.
In any event, she would have been someone who have been challenged for cause. And she also seemed to be indicating some unwillingness or discomfort in sitting on the panel. And one will note that she actually raised the concern. Counsel indicated that the judge wanted her to be on the panel. I think that was in jest, sir. If one listened to the recording, that was in jest, and counsel followed in jest as well, sir. Moving on to Shervan Hollis. Again, Shervan Hollis does not appear in the list that counsel provided, neither in their submissions in answer to the questions of this court, nor in their second list. And my humble submission, sir, would be that that's because a note was written. My learned friend said that the note does not go to the judge. That's not so. The practice is the notes goes to the judge first, then it is shared with counsel. Then we would communicate amongst ourselves, and then I may say stand by, or if counsel takes any objection to me standing by someone, he may raise it with the judge. There is no objection raised by Mr. Lynch. He agrees to the juror or the prospective juror being standby. And I say it's for that reason why counsel did not include that name in any of their lists prior to today. Ashley Lewis. That's the lady who indicated that she suffers from anxiety, depression, absolutely panic, about to have a panic attack. In those circumstances, notwithstanding the fact that it was the Crown that said stand by, I don't think counsel would object that he's objecting now, but at the time he did not object to her.
And the reasons had been given.
Excuse me, sir?
And the reasons had been given by the prospective juror.
Yes, sir.
So that was something that the reasonable, well-informed observer would be aware of.
Yes, sir. Then we come to Marion Darrell. Which we already submitted that a note was actually sent to the judge, shared amongst counsel. There is no indication of any difficulty standing by this juror, and the juror was stood by. No objection was raised by counsel at the time. And I've already given this court the errors of the recording. Listen to if the court so wishes. I'm not sure what has happened with all these notes, but I know the practice has been that the notes are given to the clerk to be kept on file. I don't know what has happened I don't know if Mr. Quayler may be in a position to assist the court, but these notes should be available.
Sorry, whose notes?
The notes during the course of the trial were notes that are sent up by jurors. They're usually handed, if there's a letter, it is handed back to the juror. If it's a note, it is handed to the clerk, and the clerk keeps them on file. So the notes should be available with the file, the Supreme Court's file.
Mr. When you refer
yes, sir?
to a letter, you mean a letter of excusal from the Chief Justice?
No, sir. I'm talking, yes, letter of excusal or usually a letter from their employer, or if there is a sick note from the doctor.
Oh.
So the judge may give it back to them, or if the juror in the box or while in court writes a note to the judge, those notes are usually handed to the clerk and they're usually kept on file.
So if it's a letter from the Chief Justice or a letter from his employer saying, I need him, that may go back to the putative juror.
It may go back to the juror, or a sick certificate that may go back to the juror. And moving on to the alternates. I concede on Ms. Hippolyte. I don't concede on Ms. Hurdle. In the court recording at 54:14 of the court smart, there's discussion recorded amongst counsel. It's not reflected in the transcript, but if one listens to the recording, you will hear that there is some discussion going on in regards to this juror.
Can one hear what the content of it is?
No, sir. And at the end of that brief discussion, Crown said, stand by.
So what are we to draw from that?
There is no objection from counsel in regards to that, sir. That was brought to the defense counsel, the basis upon which we stood by that juror.
Your schedule has a note to the effect that this juror works in the AG's chambers. Is
Yes,
that
sir.
sort of discussion you would have had with counsel?
Yes, sir. If my memory serves me well, I think she's the administrative assistant to Miss Dill, the Deputy Solicitor General. To explain the interrelationship is we're in the same building and we do encounter each other in the elevator, in the corridor. They may take stuff down to us, we may take stuff up to them. And when we do have ministry social functions, we do see each other, interact with each other at those functions. And therefore, it would be a proper cause to not have such a person serving on a jury. And Daniels, in regards to that juror, sir.
What about Chenia Headlam Latham?
Oh, we concede on that one, sir.
Yeah, okay.
Daniels, page 32. Page 32 of the actual transcript. I don't have, yes, I think that's page 400.
Yeah.
Yes, sir. And at line 13 to 21, you have any concern, Ms. Daniels? I do have a question. Someone in my immediate family has been convicted of in the certain, but I believe she did mention what it was. Would they have a conflict? And as well as knowing one of the witnesses or people that, and she was stood by, sir, which would suggest, sir, that this was a juror who was felt uncomfortable or was not sure if they should be sitting on a panel. And also if indicating an immediate family member has been convicted. That would suggest the possibility of bias against the prosecution. And I'm actually trying to remember. So in fact, I think that I may have been the person who prosecuted this lady's son many years ago. Antoine Daniels, I think is the name. I think the putative observer hearing the concerns raised by this juror would be concerned with such a juror being sitting on the panel as a impartial juror. Just double checking to ensure that I've covered the criminal indulgence. I'm just double checking that I've covered all the areas referred to by my learned friend. Yes, sir. Just a point, sir. We have been proceeding on the premise of 3 jurors. However, the actual amendment to the statute stated that if an offense is punishable with a mandatory life sentence of imprisonment, not more than 5 persons. Only in respect of Brangman, who was convicted of, I think, attempted murder, that I think the 3 juror watermark should be applied. In regards to Roberts and Smith-Williams, they were both convicted of premeditated murder. And therefore, the actual figures we should be looking at is 5, not 3 for those 2.
Wait a moment. But I had thought well, the section 519, it's unamended in its original form, said an accused person arraigned on an indictment for an indictable offence may effectively challenge without cause if he is charged with an offence punishable with death, not more than 5 persons, or in any other case not more than 3. So the relevant number of challenges as at the time of these convictions was 3, but none of the offences were punishable with death.
Well, my lord, in the subsequent case of Cleveland Rogers and Katrina Burgess, it was successfully argued before the court that it would really be 5 and not 3. Because although the sentence is not punishable, well, the offense is not punishable by death anymore. The same principle applied to the offense of murder, which would be 5. And it is from the ruling of the court in that matter that when the section was amended, it was amended to reflect that particular aspect of the law.
So were in Roberts and Smith Williams given 5 challenges?
I don't think so, sir. The point wasn't taken, but the point was taken subsequently, and the court ruled that the point was correct.
Was that a written ruling from the court in the case of Burgess and Rogers?
I would have to check, sir. It was made during the course of the trial, but I have to check if it was reduced into writing.
It's the judgment of Simmons J.
Then can that be sent to us?
Yes.
So can I just understand this? In Roberts and Smith Williams, they were not afforded 5 challenges. The decision that if you were charged with an offence punishable with mandatory life sentence, you got 5 challenges. Was that decided after the cases in Roberts and Smith Williams?
After, sir. But in the case of Smith Williams, he challenged only 1 person. So he can't allege being deprived of his additional 2 challenges.
And what about Robertson?
Criminal indulgence, just check my notes.
Roberts was jointly charged with Dewar, though, wasn't he?
Yes, and Roberts challenged 3.
Yes, he challenged 3, sir.
So Roberts challenged 3. Start again. In both Roberts and Smith Williams, they weren't afforded 5 challenges. Smith Williams, in fact, challenged only 1. Robert challenged 3. And the law that said you could have 5 if you were prosecuted with an offence with a mandatory life sentence was after the Roberts case, was it?
No, well, sir, it's a question of interpretation, sir. Different judges interpret it differently, but I just indicate that in the case of Rogers and Burgess, that trial that occurred last year, January to about March, it was interpreted differently before Justice Simmons, sir.
But was that the first time when somebody had said you can have 5 years?
Challenges.
5 challenges, sir.
Challenges, sorry.
Yes, sir.
So the position at the time, the relevant time, was that they were only entitled to 3.
Yes, sir.
Right. Okay.
As regards the disputed standbys, Mr. Mahoney, on the letter from Mr. Lynch of the 26th of February, the name Ranald Matthews, juror number 22, also appears. I don't think you addressed that one.
Well, my lord, Mr. Lynch indicated that he had no issues with that person when he went through the list yesterday. If I'm correct, this was the person who said they were related to Miss Greening, and Miss Greening had appeared in another matter in which Troy Harris had given evidence. That was
Mr.
Trevor
Sorry,
Portas.
if I may just interrupt for clarification. The letter is wrong. It's based on my reading the transcript and not actually listening to the audio. Renal Matthews should actually be Anna Anthony, who said she was related to Miss Green. Renal Matthews was actually the juror who was replaced by the second alternate, Mr.
She was the school psychologist.
Yes.
That's right. Just so that we can put this to bed, what we raised in that letter is clearly wrong. We've looked at we've listened to the transcript, and so the position is that neither of those is there an issue taken with. So
neither Anna Anthony nor Ronald Matthews.
No.
Thank you.
Unless I can assist the court any further, those are my submissions, sir.
Well, yes. I mean, what you get to on that is that there are five standbys that you accept.
Yes, sir.
And where does that take us?
Well, it takes me back to the point that I made yesterday, sir. Relying on Bestel, indicating that the mere numbers as a result of the change in the law by itself is not sufficient ground of to justify or to meet the test for the conviction to be overturned.
Yes. I mean, I don't want to go back into what we went through yesterday, but on one view, Bestel doesn't actually say anything about mere numbers, and says that the test is whether there's a substantial injustice. And what he said is that there was a substantial injustice because the reasonable observer, looking at what happened at the time, would think that there was a real risk that the jury was being fashioned in such a way as to favor the Crown, either by excluding jurors who the Crown didn't want to have, or failing to include those who the defense might want to have, which gives rise to an appearance of bias. Do you want to say anything about how we should approach, if that is a relevant question, how we should approach the question of appearance of bias?
Well, my lord, as I indicated earlier, that in respect of the question of bias, sir, the presumption of bias in favor of the Crown in the context of Bermuda, the small jurisdiction that it is, is not actually accurate or should not be seen to be that it must be a bias against the defense. Put another way, sir, many times persons are stood by because of persons who may be known to the prosecutor, known to the victim, or otherwise connected to a party in the case. And it would not necessarily be accurate that the reasonable Bermudian observer will automatically assume that there is some bias against the defendant when there's a standby of a prospective juror.
But isn't that submission, Mr. Mahoney, in effect asking the court to recognize a presumption in the other direction, i.e. that the Crown only exercises its right to stand by for good reason?
That is so, sir.
Well, is it also fair to think that the reasonable observer would expect the Crown to have expressed that good reason?
That is so, but at the time, the law was that there was no requirement for us to provide a reason. If we had to, we would have. And we were simply complying with the law and the practice at the time.
Right. Okay. Thank you very much.
You're welcome, sir.
Now, is this a appropriate time for a break? How long have we been sitting for?
There are a few observations I'd like to make to the learned friend's reply. If I may.
Okay. Well, why don't we deal with your observations and then have a break, and then we'll turn to Miss Green. Is that sensible?
So, first of all, my learned friend keeps saying, that was the law at the time. The law at the time is contained in the Jurors Act, that a court may excuse a person under section 15, so that any person who's summoned before, as part of the panel, summoned before a judge in order to try a case, may proffer any excuse for consideration by the judge. That was the law at the time. That should not have been supplanted by Mr. Mahoney or the Crown in any case, utilizing their privilege of standby. When one looks at the names of the persons that we've now spent some time going through, both from us and from Mr. Mahoney, it's clear that there are three categories. Those that he concedes, he used standbys for. Those that are recognized, and in answer to Mr. Justice Bell, he said that he conceded, I think the one for the time being, he said, I think I concede Marilyn Cooperdore. And I think the effect of his answers to questions was also that he conceded Maria Rewan, because although they are identified as having issues that could have been argued, they were not. Nothing was said. And the point is that they, on its face, appear no different to anybody who he simply said stand by.
Cupido and
I don't say.
Who's the other one? Maria Ruan.
Rowan, yes.
Ruan. Sorry, I pronounced it wrong.
I don't know if I'm pronouncing it right.
No, well, it doesn't matter.
Quite. So the position here is this: is that if one were to take into account that which he says, we're up to 5 before we get to the those that were alternates. And then there's the third category where something is said by one or more of the jurors or by way of a note, or something is said at any rate. And the standby is used at that stage. So there are these 3 categories: accepted, those where nothing was said, but there may be something that could be said later, and those where something was said at the time, but nonetheless they were stood by. In our submission, all 3 ought to properly be regarded as standbys. But a proper distinction can be drawn, of course, between those 3 categories. And I do not say, may I make it clear, I do not say that if your lordships were satisfied that where it was beyond doubt that a particular juror could not have sat, that would not come into the mix when deciding whether to apply the proviso. But it is dangerous in our submission, as I said before, for this court to seek to try and do the job that was the job of the judge at the time in determining whether or not there was a justification for cause. And that is best illustrated in the examples my learned friend relies on. Marilyn Cupido is said to be a Crown HR representative from the DPP's office. And we've had a little additional colour added to that today from Mr. Mahoney, as we did with Rewan. And the position is this, isn't it? Is that we were denied the opportunity to say anything. During the course of my learned friend's submissions, he says, well, without objection from Mr. Lynch. It's not a question of us objecting to the use by the Crown of their privilege of standby. We don't have a right to object to that at all. The judge doesn't. No one does. It's only if we get to the end of the queue that the judge would then revisit the question. So it's not a question of us objecting. We have no status to object. And so in our submission, for my learned friend to rely now, adding the colour that he does about these particular individuals, and to say, well, they would have been stood aside anyway, is simply not the point. The point is we were denied any opportunity to consider it. In the United Kingdom, as in many other jurisdictions now, judges sit as jurors.
Yes, I've done it.
I daren't ask you anything about it. I don't think we're allowed.
That would be illegal.
Quite. But what I'm saying is the mere fact that somebody works as the HR representative and may have had some connection with the DPP's office is not a basis upon which to reject someone. Now, we might have said, well, we're not really happy about that, but the judge may have taken a very different view. Knowing Mr. Justice Greaves, I suspect he would have taken a different view. But the position is this: we're denied any opportunity, as is indeed the court, from considering it. Even where, and then we come to the third category, even where something is raised. And to take an example, Ms. Simons, who was the AG Chambers office manager, and Mr. Mahoney proceeds on the premise that, well, there's no way she could possibly have sat. Why not? And that there was a degree of levity between the judge and myself and that juror, because he said he was trying to keep her. Well, there is a degree of levity. You've seen from the nature of the transcript, the judge does that. That is his style. It doesn't mean he wasn't serious. The point is it's taken out of our hands. Once the prosecution say, stand by, that is it. It can only be revisited when we come to the end of the queue, if it becomes necessary. And so it is important we submit that those distinctions are understood, and that from the observer's point of view, all he sees is the exercise of that right by the Crown without more. Last point I wanted to deal with was the 5 persons point. This is a non-point in our submission. It has always been understood that jurors that could be challenged to 3. We only challenged 1, and in a sense it doesn't really matter, because in the end we chose to challenge 1 looking at the pool as a whole. That is to say, there's little point in making a peremptory challenge, let us say, in any case, not our case, but in another case, one wanted to remove 50-plus-year-old little ladies from the jury for whatever reason. It was a sensitive case in a particular way. It would be little point in challenging 1 if the only 3 people that were left were little old ladies. So the challenge is taken. A peremptory challenge is utilized looking at the panel as a whole. The fact that there's a subsequent authority, which, if I may say so, seems to us to be a somewhat dubious authority, but nonetheless a situation in which in a particular case it was permitted for 5 challenges to be made, is not to the point. The current position is identified by the 3 that are normally challenged. The case of Trott was determined upon that basis of equality of arms. And we have all proceeded on the footing that the 3 is the permitted number. And I don't understand Mr. Mahoney to be saying, well, the position should be taken into account as it being 5, that threshold is the point at which we should stop rather than 3. Unless there's anything else that I can assist you with, those are the submissions that we make in relation to...
There is slightly. You say that all the informed observer sees is the exercise of the right by the Crown without more. But just pause there a moment. You complain effectively as follows: if a juror was to be removed for cause, that required the judge to make a decision. If he was to be excused for a reason, that required the judge to make a decision. And the effect of exercising the standby is that the judge doesn't make a decision. That the juror is simply stood by. At the same time, under the law as it then stood, that's exactly what the Crown was entitled to do.
Yes.
I can see the, as it were, the complaint or the assertion that removing for cause or excusing should be left to the judge. But the relevant, well, a relevant question for our purposes is what the fair-minded and informed observer would make of what he saw happening.
Yes.
And what he would see happening is that some jurors were stood by for no apparent reason. That includes those to whom it was simply said, stand by or stand down, and that includes also those to whom, or in relation to whom, that was said. But as we now know, there was information in the Crown's mind which gave them a reason which was unexpressed. So that's category number one, which are effectively all the informed observer knows is that they were stood by.
Yes.
The other category, the informed observer, or the last category, the informed observer has rather more information.
Sometimes.
Yeah, sometimes. Well, yes. But assume that the witness says, I'm going to suffer from panic attacks, or I've got a criminal son, or this, that, and the other. The informed observer will see that. And if he has that type of information, would he think that the Crown was or might be using its powers of standby so as to get a jury which was favourable to the Crown or not as favourable to the defence as it might have been?
Well, I don't think one can ignore those features. It would be wrong to do so, and I don't seek to argue that you should. The problem here is this, isn't it? Is that how do we understand, how does that informed observer perceive it? Let's suppose that the person who says, I had a panic attack, is just the kind of person the jury that are being sought to be removed, and the others are similar. I'm not saying in our particular case, because I don't know the answer to that, but what I'm saying is that it can't be looked at in isolation. Somebody says, my son has been convicted. The informed observer will say, what, for drink driving, or how long ago, for what? But you're just the category of people that are being excluded, or have been hitherto, by the Crown in the utilization of the standby. The problem is by doing it that way, by taking advantage of what they perceive to be their right at that time, it has denied it, the casual observer, the informed observer rather, the opportunity to actually have any proper understanding of why that person's being set aside, and more importantly, denies us the right, that is both the judge and the defendant, the right to be able to say, well, just a moment, before just saying that you've got a son who's been convicted. Again, we've had a little more color added to it today, but the position at the time is the informed observer just sees somebody saying, well, I've got a son who's been in trouble, or been convicted. So what? They wouldn't necessarily think, oh, well, that's a good enough excuse, would they? I would hope not, because that isn't a good enough excuse on its own to be excused.
But the fact that the exercise of the then existing right of standby denies you the right to join issue with the exercise of that right doesn't necessarily mean, does it, that the informed observer would think that the exercise of that right indicates a real risk of bias?
Well, you could argue that it doesn't. You can argue that it does. That's the problem. That's why we don't look for bias. We look for whether or not there is an impression, the appearance of bias.
Well, that's why I use the expression real risk.
The expression, exactly. So we would submit that it does. It does precisely that. It creates the appearance of bias because it looks like the person who is making the decisions is not the judge, as is required under the Jurors Act for where it is for cause. So if you're taking away from the judge the duty that he has to explore any avenue for cause, and you take away from the defense their right to be able to consider the question of cause and make any representations on it, then it does have the appearance of bias in the hands of the Crown, utilizing a power that seems limitless.
Is there an informed observer to know the provisions of the Juries
That may
Act?
be going too far, because I think that may be going too far. I had to check it myself. But if we start from the premise that the court has a duty imposed upon them by the Jurors Act to consider excusing any person who has a proper basis to be excused, and that duty involves hearing both from the Crown and the defense in order to make a judgment. And sometimes that can be very quick, can be, and we've seen it happening very speedily, where there's an obvious reason. The person can't say, I've got a booked holiday, I'm away on business in this period, those sorts of things. No one's going to object to that, but it shouldn't be utilized by way of a standby. It's not for the Crown to seek to take advantage of their limitless power that is declared now to be unconstitutional to usurp the authority of the court and deny the defense.
Yes. Well, that may be a feature of the want of equality of arms point.
Yes.
Because one can see, let's assume in every case where there was a standby, the putative juror said quite a bit about his or her problems or the people whom he knew.
Yes.
And in each occasion, he or she was stood by. It might be that the informed observer would think that the informed observer, blissfully ignorant of the provisions of Section 519 of the Act and Section whatever it is of the Jurors Act, wouldn't think there was any reason to suppose that the prosecution was producing a jury biased in its favor if it sees that the reason or the circumstances in which the standby took place were because the putative juror had spoken about his problems or how much he knew others.
Is that, sorry.
No, go on, do interrupt.
Is that right though? I mean, if we're an adversarial system,
yeah,
we have a system which allows equality of arms on each side. It seeks to guarantee that constitutionally. The idea that somebody can be descending into the arena on one side and be making decisions that the Act specifically provides should be made for by the judge without any input from the defense seems completely wrong, if I may respectfully say so.
Yes, well, that's the equality of arms point.
Yes.
Which is, there are two different points. One is appearance of bias. The other is equality of arms, and the Chief Justice decided on both of them. All I'm saying is that it's possible that an observer might, in the light of what all these putative jurors had said, think, well, there's no reason to suppose that there's a risk that the prosecution is using its absolute powers in order to obtain a favorable jury. But at the same time, it could be said that the effect of the prosecution using these powers is that there was not an equality of arms, because although you could only remove, in effect, for peremptory reasons. 3, the Crown could remove any number, and therefore avoid the necessity of the court, which would otherwise arise, of the court reaching a decision about either cause or excuse.
Yes.
Yeah.
Yeah.
Okay. Sorry, there are just some musings of mine.
That's fine. I'd rather be here to hear your lordship's musings than once we've adjourned your lordship musing and then I'm not able to say anything.
Yes, yes. Well, sycophancy will get you anywhere.
Well, I'm doing my best.
No. Okay. Well, we'll adjourn now, if we may.
I've just, for the court's attention, I've sent the authority that Mr. Mahoney referred to that was issued by Justice Simmons.
Okay.
Thank you.
Thank you so much. See you in an hour's time. Thank you.
So he doesn't say how long he's gonna adjourn for. An hour. An hour.
Do we have the appellants? Lord President, you're muted.
Yes. Are we all present and correct, or at least all present?
Yeah.
Right.
First pages.
Ms. Greening, I think it's your turn.
Yes, I think it is. Good afternoon.
Good afternoon. I'm sorry if I may have appeared a little querulous at close of play after a long day last night.
No, I hadn't noticed. I think we're all just bogged down by these interesting
Yes.
and issues that we're grappling. So would his lordships like me to go straight into the transcript?
Yes, just before we start, I'm just wondering what in the Roberts case is the relevant disparity, because in the other cases we've been saying that if you get above 3, you go beyond the limit, but in Roberts there were of course 2 defendants.
Yes.
So
Well,
is the
I'm concentrating solely on Roberts and his right to challenge 3, as opposed to the prosecutor's unlimited right to challenge or stand by.
But excuse me, Ms. Greening, is the prosecutor's standby right measured against the 3 of Roberts or against the combined total of Roberts and Dewar?
Sorry, I said it the other way around. Against Roberts only, because he has no control over what Dewar does. Dewar could decide not to challenge anyone. But my argument is the prosecutor had the right to stand by an unlimited number in the pool, and my client Roberts only had the right to challenge 3.
Yes,
we understand that. We can perhaps come back to it, but I was thinking from the equality of arms point of view, whether it might be said that the Crown's number of standbys should be measured against the number of peremptory challenges available to the combined challenges available to both defendants.
No, in my submission, absolutely not, because Roberts only has control over his 3 preemptory challenges. He's only afforded 3 preemptory challenges, and he has no control over what Dewar has. He has no right over what Dewar's to do with his. It's purely the equality of arms principle is applicable to each defendant in the box in their own right. It can't be that the equality of arms takes into account the rights of other accused who are in the dock next to you. That's my strong position.
Yeah, you may well be right on that. The legislature doesn't seem to have thought so, because in the saving provision 5.2, it says, accordingly, no conviction should be quashed solely on the ground that it resulted from a trial in which the Crown stood by more potential jurors than a defendant or defendants together were able to challenge without cause.
Well, that's the law now. I just can't see how we're looking at it through the lens of fairness, and each appellant or defendant at the time had the right to a fair trial themselves. How whatever is going on with someone else could have any bearing on what their rights are.
Yes.
And if we're going to now go into the fair-minded.
Good afternoon. The appellants can't see Ms. Green or a few of the appeals members.
Okay, but also I'm noticing that Mr. Brangman is not in the room.
Yeah, he just stepped out, is actually not feeling well. Trying to get him back in his seat as we speak. I want to bring that to your attention also.
We need to wait for him to come back.
But yeah, we would need to secure his okay if he wants us to proceed without him.
Do we know where he is?
Oh. Yeah, he just stepped outside the room. Here he
okay.
is. You know, all right, I think we can carry on. We still can't see the other appeal members still, and if the video is off, I guess. Mr. Roberts just brought that to my attention.
Well, can you see everyone else?
We only see Val and the president and Mr. Quayler.
Yeah, but everybody's still there.
Okay, well, all right to proceed. They just want to bring it to your attention.
Okay, well, as long as you can, that's fine. Thank you. Right.
I'm just thinking through so each defendant had the right to stand by up to 3.
Yeah.
Not stand by, challenge up to 3.
Yeah.
Now, the Crown and defense collectively have the right to, I don't know what the correct term is, stand down by agreement.
Sorry, what are we talking about? The Crown or the defense?
The Crown and defense now, under the Amendment Act 2020, can stand down potential jurors by agreement, or if it's not a murder case, and that includes and in the dock.
I'm not absolutely sure that's right. What the section says is, I don't know whether you've got it to hand.
I will in 1 second. Yes, okay.
It says an accused person arraigned on an indictment for any indictable offence, and the Crown in relation to each accused person may each effectively challenge without cause, and then it's either 5 or 3. Now that makes plain that the accused can challenge accused. Yes, each accused person can do that. So that if there are 3 accused persons, there can be 9 challenges without cause, and the Crown would have the same number, wouldn't it?
I see. And then looking at the saving provision, it's now saying that we can't go back solely on the ground that the Crown stood by more potential jurors than a defendant or defendants together.
Yeah.
And so the question, I understand now. So the question is, because there were 2 defendants in my appellant's case, and they could they stood down a total of 1, 2, 3, 4, 5 altogether, because my client stood down, my client challenged 3 and Dewar challenged 2. That's 5 altogether. Well, in my submission, the answer is academic because, well, the answer, I suppose, is clear. In looking at the saving provision, it seems as if the test, if that's the right word, would need the burden of demonstrating substantial injustice would on the appellant would need to show that the Crown stood by more than, in this case, 5. And in my submission, the Crown did stand by more than 5, because the argument that that the members of the public and the jurors about to sit and try the case sees the prosecutor standing by more than the defense are allowed by law, and then automatically the appearance of bias arises. That's
just a moment.
overriding argument.
What?
That's my overriding argument.
Sorry, can you just wait a moment? I've lost the unamended provision. Well, wait a moment. Was that an accused person arraigned on indictment could stand aside not more than 3 persons. That was the arrangement which existed at the trial. Forget about the amending act for the moment. At the trial, the accused could stand by 3 persons, and the Crown had an unlimited number. And you say,
well,
what?
It seems as if the saving provision is inconsistent with what
the saving provision doesn't arise, because we're talking about the position at the time of the trial.
Yes, and I'm just referring to the saving provision because it seems to be irrelevant what the saving.
I think it's helpful, Ms. Greening. Let's talk about the position at the time of the trial.
At the time of the trial, each accused, in and of themselves, had the right to stand, had the right to challenge 3.
Right.
In terms of equality of arms, that is unfair. That's
yes.
Equality of arms, because
and you say the inequality of arms has to be measured in relation to each accused, because the accused can only exercise his rights. So it's 3 for your client and 3 for anybody else.
Yes, and then
and that has to be compared with infinite. I mean, with any number.
Yeah, I mean, to me that just seems so obvious that it's difficult for me to even. But yes, so my client, Mr. Roberts, was allowed to challenge 3, and it's unfair and it's not equal for the Crown to be able to stand by as many as they want. To make it equal, in fairness to the Crown, as well as in fairness to the accused, one would think that the Crown could then stand by as many. So each defendant then still has their right to preemptory challenge of 3.
Mm-hmm.
Depending on what the charges are. And then the Crown would have that same number to make it equal, depending on how many defendants there were. But instead, the saving provision is now saying that no matter how many defendants were in a trial pre-amendment, we can only go back in time if we can show that the Crown stood by more potential jurors than the defendants collectively, which can't be right. So in my submission, that can't be right. My client only had a preemptory challenge of 3. If there are more than 3 stood by the Crown, then it's unfair. It creates an appearance of bias and it offends the principle of equality of arms.
Yes, you're right. The saving provision appears to provide that no conviction, and that must be no conviction before the passing of the Act, should be quashed solely on the ground that it resulted from a trial in which the Crown stood by more potential juror than defendants together. So in your case,
5.
where the Crown stood by more than 5.
Well,
no, it's no, wait a minute, it's actually 6.
We're able to challenge for cause. So the fact only 5 were challenged is
doesn't matter
to that saving provision. That's even that seems to be even more absurd.
Yes, it's not did challenge, but we're able to challenge.
No, that's not right. In my
Well, you say that that's a reason for. I think you would say that's a reason for regarding 5.2 as unconstitutional.
Absolutely.
Yes. All right.
Absolutely. That word, it should be taken literally.
Okay.
Here, and Miss Greening,
yes.
What you say that 5.2 says? I wasn't clear on that.
Well, 5.2, if you read it literally, says that defendants collectively were able to challenge for cause, so that it doesn't even mean let's look at the numbers and see how many Mr. Roberts and Mr. Dewar actually challenged, which is 5. The saving provision seems to suggest that because 2 defendants could challenge up to 6, that's the number that needs to be looked at as against how many potential jurors the Crown stood by, and that's offensive to the equality of arms and principles of fairness.
Are you saying that it precludes the sort of inquiry that we have been engaged upon?
No.
Read as a whole.
Well, it seems to make somewhat of a mockery of this whole situation, because if we're looking, we've spent the last 5 days or longer looking at each potential juror and what happened and what category they fall under, to see specifically whether this process carried out by the Crown offended the principle of equality of arms, whether the fair-minded observer would think it was unfair or created appearance of bias.
Why do you say that the proviso precludes that? Why do you say it precludes a conclusion that the trial may have been unfair because of the fair-minded observer being concerned about the process?
Because my client...
No. If you read the proviso again, it says that a conviction shall not be quashed solely on the ground.
Well, yes, I see what you're saying. It goes back to our argument about the test that needs to be applied, which is one of substantial injustice.
Well, quite. That's exactly why I asked the question I asked. What do you think it precludes this exercise?
And whether or not the facts in each particular appeal amount to substantial injustice, more than just an exercise looking at numbers, exercised by the Crown as against the defendant or defendants.
Right, which is rather the way I read it.
Yes. So where does that leave us? Should I was going to summarize.
Well, just a moment. You say the test is one of substantial injustice.
Yes.
I thought you said before the test was one of either apparent bias or inequality of arms.
Well, what I say is that that I am arguing the appearance of bias that arises, and the offending of the principle of equality of arms, and my submissions in support of those, in support of that, and the law that I have brought to the court to support that, is what demonstrates the substantial injustice.
Yes,
The
I see.
constitutional unfairness
Yes.
is what demonstrates the substantial injustice, and
Yeah.
is why the conviction needs to be set aside.
Right.
In reply to his lordship's musings before lunch,
Yes.
just to use your word,
Yes, I
submit that and his lordship said, or was wondering whether the court is bound, and I remember you used that word deliberately, I think, is bound to consider the appearance of bias. And in my submission, and I've made the submission already the other day, this court, this honorable court, is bound to consider the appearance of bias given the facts before it at these particular appeals, because it amounts to a de novo unfairness to the accused pursuant to this case Miller and Dixon, that is a Privy Council case that binds this court. The fact that they did not provide a reason at the time misses the respondent is saying that they didn't have to provide a reason at the time for why they were standing by. That was the law at the time, but it misses the entire point of the appearance of bias. The temporary sheriffs in the Miller and Dixon case were perfectly entitled to sit, and the defense lawyers at that time didn't object. But the appearance of bias found by the judges at the Privy Council, which was held to be incompatible with the appellant's rights, meant that the convictions had to be set aside. And this is the situation here. And in my submission, it's even more of an infringement of the appellant's rights in this case than it is in a case where a temporary sheriff, who probably isn't trying to advance his career by convicting or acquitting people, was still held to create an appearance of bias to the extent that those convictions were set aside. Here we have a situation where, I mean, in the Trott case, we had the affidavit of the fair-minded, informed observer sitting in the public gallery saying, I looked at this and wondered what on earth was going on. It seemed unfair to me. We have, if it's accepted, the affidavit evidence of my client who said, I felt that it was unfair and I still feel this way.
Yes, I'm not sure that is actually going to help us, because evidence from an individual is not the test. The fair-minded and independent observer is a legal construct, and we have to determine what a fair-minded and independent observer would think. The fact that other people might think the same is neither here nor there.
Well, I mean, look at it another way. The Attorney General's guidelines are clear that the exercise of this provision given to the Crown should only be used sparingly to avoid it being used for tactical purposes, to paraphrase it. The respondent submitted yesterday that the AG guidelines are not applicable here in Bermuda. They are persuasive though, and they deal with this with a very general concept of fairness. It's not as if they're dealing with a very specific type of law. They're dealing with a very general concept of fairness. There is a case here, a recent case of Lambert, where Justice Hellman relies heavily on legal guidance from the UK in coming to his decision about the constitutionality of prosecutions in Bermuda. And I would ask, I can send that case to Mr. Coelho if the court would like me to, but it's just an argument in support of why the UK AG guidelines ought to be considered by this honourable court.
What's the year of that case, Ms. Greening?
Just a moment. It's 2016, number 199.
2015?
16.
2016.
Yes, I'll send it. I have.
We can find it. I can find it. Could you send it, actually?
Dwight Lambert. I've
Please
highlighted,
write the name of the case, just for my note.
and for the record, yes. Dwight Lambert is the plaintiff versus minister responsible for telecommunications.
Didn't that come on appeal before this?
Yeah, that rings a bell somewhere.
Well, I think it was in relation to the damages that it went to appeal. In relation to the constitutional. Sorry. I crave the court's indulgence for just one moment. You know that case of Lambert?
Yeah.
It went to appeal for damages only, didn't it? The constitutional.
No, it went on appeal.
Oh, I went to the Supreme Court because it was a
Yeah, for
magistrate's court
damages
case.
only.
Yes, that's right. Send it now.
I believe it was the judgment of my Lord Smelly.
No, I don't think so. I think maybe Justice Gloucester may have written in that.
Well, I have it here. Should I send it?
Well, it's not the Court of Appeal case that I'm sending because that was in relation to damages only. This is in relation to the constitutionality of prosecutions in Bermuda, and I'll send it to you right now.
It was in relation to a charge of having obscene material or something of the sort.
Yeah, that's it.
Yes.
That rings a bell.
But the judgment of Justice Hellman was not appealed.
No. No. It's my own downloaded copy that I've emailed to Mr. Coelho. So the relevant sections are highlighted in yellow, where you can see submissions are made about these UK guidelines, and the judge has relied on them heavily in his conclusion and decision. All that is to say is that respectfully, I don't agree with the respondent's submission that this court cannot, that the AG guidelines in relation to jury selection are not applicable here. And in my submission, well, maybe I should just wait until everyone's ready because that's my next point. The fact that the guidelines specifically state that the Crown's privilege is only to be used sparingly, not to be used for tactical purposes, is deliberately worded in that way because it is warning against the creation of an appearance of bias or actual bias. It doesn't matter if the Crown has a reason. They're guided by the AG's guidelines only to use their standby sparingly. In fact, there is if you look at the transcript in the jury selection process of my case, you can actually see Mr. Richardson, who represented my client, suggesting to the judge and to adopt Mr. Lynch's observation that we need to look at this in context of Justice Graves's style. He is page 52. Mr. Richardson is saying to the judge, I think we have to, oh, that's about calling the standbys in order. Sorry. No, it's page 79. Mr. Richardson says, perhaps just as a formality, you should be inviting some representation from us before you rule. And the court says, I know you don't want to make any representations on that. And Mr. Richardson says, well, just as a formality, maybe you should invite us. And if you look at it in the context of what's going on there, basically the Crown and the judge and the prosecutor are having a conversation back and forth with no input or invitation for representations from the defense lawyers about what to do with these jurors who are giving excuses, and the court is deciding whether to challenge for cause. That's right after the judge has made a comment saying, I think this is my longest jury selection ever.
So where's that?
It's at page 76 of but I'll have to look at the record of appeal. It's at page
Could you say what page of the transcript it is?
it's page 76 of the transcript, and I'm going to tell you what page of the.
Well, that's 324 of the record of appeal, but I can't see.
Yeah, so it starts at line 25 of the transcript.
Oh, yes, I see. Yeah.
324. The court says, I think this is my longest jury selection ever. And I think we can take judicial notice of the fact that Justice Graves has sat on a lot of jury trials. And then if we go 2 pages on, or to page 79, you can see that there's discussion between the prosecutor, the junior prosecutor, Miss Smith, the court, the potential juror, the prospective juror, and then the note, there's something getting passed around, and then in the middle of page 79 of the transcript, line 13, Mr. Richardson says, sorry, my lord, perhaps just as a formality, you should invite some representation from us before you rule. And the court says, I know you don't want to make any representation on that. Mr. Richardson says, well, just as a formality, maybe you should invite us. And the court says, well, I've been doing that all along when I think it's not as obvious or not. When it's certain, I've been doing it all along. So the decision that I can make on the submissions of the Crown alone, there are times when I will need the defense to assist in the circumstances. When I think it's not, I do not. Still my discretion in the end, all the time. All right, okay. So we move to the next one. What do you think that, what do you think impression that creates in the fair-minded, informed observer sitting in the public gallery? The court is actually saying out loud that he can make a decision on the submissions of the Crown alone, but it's up to him ultimately. Sometimes he'll ask the defense, but it seems if you look through this transcript, he hasn't ever asked the defense. Pretty damning, one might think. I mean, this is getting towards the end of certainly more than halfway through the second half of the jury selection process. When,
but if that goes anywhere, it goes to an impression of bias on the part of the judge, not the Crown.
What does it matter? If we're talking about the jury selection process and the appearance of bias, whether the judge is buying into this idea that the Crown can offend the equality of arms, or whether the prosecutor is abusing it, it doesn't, it still leads to the same place. It's the appearance of bias on the trial process. That's my submission since the beginning, not on the jury. There's been a confusion about that, you know, because these are difficult issues to grapple and get your head around, but it's the appearance of bias on the on the fairness of the trial process pursuant to Miller and Dixon, that Privy Council case. It's not, no one is saying, I don't think that, no one is saying outright that the jury have been contaminated and tainted by this unlimited standby by the Crown. It's the appearance of bias that it creates on the whole process, the unfairness to the defendants, the appellants, which goes back in my submission to why the AG in the UK have deemed it necessary to put these guidelines together to warn the Crown not to abuse its privilege, to use it sparingly. Otherwise it will, you know, and not to be used for tactical purposes.
I'm sorry, I'm a bit lost. I had thought everybody was saying the way in which the Crown acted, that is to say, by standing people by in excess of the 3, gave the appearance of bias because the fair-minded observer might think that there was a risk that that meant that the jury would be biased, either in the sense that it had people put onto it that that it had people taken off it who the Crown didn't want, but whom the defence might. And also that there was a lack of equality of arms, because the effect of the Crown having unlimited rights of standby is that it could exercise those rights, which, if the standby was effective in the sense the matter never came back before the court, would mean that the question as to whether a juror should be excused or whether the juror should be removed for cause would never be raised, and the defence would never be able to deal with it. As I thought was the whole basis of the claim that was being put. Well, now you say no one is saying the jury has been tainted by unlimited standby.
I can't speak for Mr. Lynch and Mr. Pettingill because they have a different situation going on with their numbers. What I can say, because at the end of the day, as we were saying yesterday before we adjourned, at the end of the day, there are two prospective jurors who were stood by the Crown. No cause was established when they came back the second time round, and they ended up sitting on the jury.
I thought it was 3.
Yeah, it was, and I don't have the name of the third one. I've got Sanchez Wilson and Troy Baisden. I don't have the name of the third here. Then we have.
Wait a moment. Just a moment. Sanchez Wilson ended up sitting on the jury.
Yes,
so did Troy Baisden.
And then Gina Dean.
And Gina Dean.
Yes, that was the third one. But, well, Gina Dean is slightly different from the other. Gina Dean was stood by with no reason given whatsoever, just stood by on a flat standby. And she ended up coming back and she sat on the jury.
Right.
Sanchez Wilson, she was stood by. She came back and she gave a reason, and the reason was not sufficient for cause to be established, so she sat. Similarly, Troy Baisden was stood by. He gave a reason that he worked at Belco, I think, and that was no cause was established there, so he sat on the jury.
Yeah.
Then there was Jaina Heineke. She was stood by, but then she was never called back the second time round. So in respect of her, the Crown...
Sorry, where is she? Where is she?
Repeat that name, please, Ms. Greening.
Doesn't seem to be on the list.
Yes, Jaina. She's number 32.
What? Juror number 32?
Yes, she's juror number 32. And she, I can tell you,
You please repeat that name.
Jaina Heineke, Jyna Heineike.
Thank you.
She doesn't appear on the list at all.
No.
She's at page 29 of the transcript, which is page 277 of the record of appeal.
Could it be that she should have been where Angela Campbell is on the Crown's list? The bottom of page 3.
I don't.
No, wait a minute.
I don't know.
Page 29, sir.
Okay, I'll stop at the other one.
At line 16 on page 29,
Yes.
the court associate says, Jaina Heineke, you come forward. You're not going to be here on April the 17th. So where were we? Right. Now down the back line again.
And then lawyer Attridge is my legal counsel. So is that the prospective juror talking about Attridge is not anything to do with Heineke?
No.
Doesn't seem so.
Doesn't look like it. That must be Angela Campbell.
I see. Okay, so Jaina Heineke is never stood by. She's just sent away because she's excused. So the other one on my list is Patricia Smith, which...
Wait a minute, so she is excused by the judge?
She's excused by the judge, yes.
Okay.
So Patricia Smith is the one that is stood by with the reason that she's friends with the deceased, and she's never called back. I think she's number 1. Oh, she's number 53.
Is she on the list?
She's not referred to by the respondent in the respondent's list. She is referred to in the letter that's sent out by the courts asking us what happened to her.
A moment.
She's on page 52.
Yes.
At the first, on page 16 of the transcript.
Yes.
was the first reference to her. That's when we're going through the prospective jurors the first time round. Court associate calls number 53, Patricia Smith. The court says, yeah, you're going to have a lot of that up and down, you notice, so I hope you have some strong knees. This is economy class, you see. So where we were at now, who was the next one?
Miss Greening, for my part, I really would find it helpful if we went through these in some sort of order, because it seems to me that we are dotting all over the place and frankly losing focus.
Okay, well, what I had planned to do was go through the list of 13 jurors that were stood by without any reason given at the time. Those are the ones that I had wanted to draw the court's attention to.
Okay, but just before, once we got on to Patricia Smith, did she in fact serve on the jury?
No.
Can't hear.
No, she didn't.
So it's impossible to see what happened. I mean, she obviously has some difficulty getting to the jury box, and the judge says she needs strong knees. And then she just fades away.
And then she comes back again. So
where does she come back?
The fact that she's come back, so nothing, there's no indication of what happens to her here on page 264.
Yes.
After the judge talks about economy class.
Yes, yes.
And then she comes back again on page 52. By this time, the standbys are being called the second time round.
Yes. Oh, yes, I see. Just going, so I think I'll let you stand down, I'll exercise my discretion. My condolences. So that's the guy whose brother had died. And then Mr. Smith, that's the juror, says, thank you, sir. Then the court says, Patricia Smith. Now I have, in my table, I have taken that to mean the court is now calling back the standbys for the second time round in order. Yes.
Mr. Mustard, so she must have been stood by the first time round, but we're not sure about that because there's nothing said. But you, by inference, she has been, because now she's being called back. Mr. Mussenden says, my lord, the court associate says, I have 60. My lord, the order, and this is something that's raised on a number of occasions by the defense. They're because the standbys are not being called for the second time round in the correct order that they're supposed to. And then Mr. Richardson says, I think we have to call the standbys in the order that they were stood by. The court says, that's the order. I have her at P4. I don't know what P4 means because P4 isn't a thing. Court associate says, I have 30. So there's a confusion all over the place about, the court says, huh? Mr. Richardson says, no, my lord, that was a recent standby. We've got a lot more to go through first. So what he's saying is that Patricia Smith was stood by, recently, and that we need to go back in order and go through all the ones that haven't been called for the second time again yet. The court says again, Patricia Smith, I have at P4. Mr. Richardson is saying, no, my lord, the court number 53. I have, Mr. Attridge says, I have 60, 41, 29. Mr. Mahoney says, she's 15, sir. I think what he means is that she's the 15th one that was called. The court says, huh? Mr. Mahoney says, I think she's number 15. Mr. Mussenden says, 35 is what I have. Who you have as the fourth stood down? Mr. Mahoney says Trevor Smith was number 4. The court associate says it should be 60. So we never really get to the bottom of what's going on with Patricia Smith there.
But what happens to her?
Well, I have made a note that she said somewhere that the deceased is her friend. And she's not mentioned.
Schedule attributes that comment to Leon Simmons at the bottom of page 1 of the Crown schedule.
Excused deceased Outerbridge was her friend.
Yeah.
So it appears as if Patricia Smith was stood by first time round.
Mm-hmm.
No explanation in the transcript, at least, as to why. She's then called back.
Yes.
And we don't know what's happened to her after that. As
Right.
she must be in the wrong seat. I must have wrote down the seat number, number 60. Yes, sir.
Where are you reading from?
Sorry, page 53 of the transcript.
Right. And Mr. Smith says I'm at 60.
Yeah.
I think it'd be very difficult for us to sort out this confusion in the time that we've got available. And I'm a little concerned that we need to be addressing your number of standbys.
Yes.
Just before we address your number of standbys, I understood you to agree that the Crown stood by 33, which is what appears in their amended schedule, that 28 were excused, either excused or removed for cause, and that 3 were impaneled, so that there were 2 which were left stood by without having been excused or held to be a cause established for their not sitting. That's what you told me, confirmed yesterday.
Yes.
Which are the 2?
Well, the 2 I have on my list are Jaina Heineke and Patricia Smith. Those are the 2 that didn't get called back.
We see that Yaina Haneke was excused by the court. We sorted that out earlier.
Who are the two that the respondent is saying were stood by and not called back?
Well, I think I know the answer, but rather wearisome that nobody seems able to provide it. If you look at page 2 of the amended schedule of jurors.
I've got the re-amended, yes.
The re-amended, okay. I had understood that the 2 who were stood by and then second time round were not excused or pulled out were juror number 28, standby number 15, and juror number 42, standby 17. Perhaps Mr.
Those are the numbers that I had recorded previously.
Yes. Yeah, quite.
Linda Graves and
Claire
Mello.
Claire Mello.
Yes. And I think Mr. Mahoney confirmed that was so. Is that right? Is that right, Mr. Mahoney?
Sorry, sir, I'm double checking with my colleague. It was Linda Graves and who?
I thought we had Claire Mello that was stand by. It is on that right.
The 2 who were left after everything. Crevendo. I'm just confirming with my colleague.
Yes.
Just stood by for the time being, yes. And then and this one, Claire Mello stood by for the time being on the other side.
So it was Linda.
And that's Claire Mello, he stood by for the time being.
Linda.
And 42.
Linda Graves.
Yeah, both of them stood by for the
And
time
Claire
being.
Mello. Linda Graves and Claire Mello, sir.
Yeah.
Linda Graves is on page 18 and Claire Mello is on page 19.
Yeah.
And then they don't get called back again.
They're both.
No, they do get called back again.
Page 73. It's 321 of the record.
Yes.
Okay, Linda Graves gets called back again.
Yes.
And
Yes.
And my lord, Miss Gina Heineke, she actually sat on the panel. If you look at the Miss Allboy's affidavit, the exhibit that relates to this matter, it's exhibit EA1. Anarchy was juror number 5, who was eventually released.
In just a moment. She was juror number.
Number 5, sir.
Yes, she was. Right. So where we've got to is that Heineke was not excused by the judge. She was juror number 5. Patricia Smith, we can't work out what on earth went on. And what is said is that, and has been said for some time by the Crown, is that the only ones who were stood by twice, as it were, in other words, were not either ruled out or excused second time round, were Linda Greaves and Claire Mello. Now, that was what I understood to be agreed as a result of your email to the court. Because you said, I don't argue with the Crown as to the number of standbys, those excused, challenged, or who eventually sat as jurors. Now, are you resiling from that or what?
Well, those were the numbers that I came up with as well, but it seems that the people attributed to those numbers are not the same as the people attributed, but I can see on page 72 that Linda Graves was recalled and then she didn't, nothing happened to her. And then Claire Mello was her standby continued second time round.
Yeah, well, if you look at Linda Graves, she's on 72.
Yes.
And she talks about leaving when she expects to get back.
Mm-hmm.
And the top of page 73, or Record of Appeal 321, the court says, okay, I think we can agree that Miss Greaves should stand by for the time being.
Yes. And
so this is not the Crown doing anything, it's the court. Mr. Mahoney says yes. The court says, can we all agree on that? Mr. Mussenden says yes. So it's the judge who stands her by with the agreement of the prosecution and one defense counsel.
My lord, the point is that would, the first time round, the prosecutor takes it upon himself unilaterally to stand her by.
Yes.
And the second time round, the court does not excuse her with cause established. He continues to stand her by, the standby of which would not exist if it hadn't been for the Crown standing her by the first time round.
But it is the court that does it the second time.
Yeah, well, but unlike the other ones where he has looked at the jurors the second time round, either used his discretion to excuse the judge, either used his discretion to excuse the juror, or turns to the prosecutor to hear representations on whether cause can be established. In this case, he's saying, okay, well, he's not saying that. He's not saying cause has been established or not established. He's saying that the standby that the prosecutor put you on originally, that's my insertion of that bit, will continue. And so, but for the prosecutor standing by of his own accord, she wouldn't be in that position. If she hadn't been stood by, well, we never know. If she hadn't been stood by the first time round, there's nothing to say that the court would have agreed that her travel plans in the first week of April for just a week would be enough to
Just don't know.
Enough to kick her off the jury. We don't know.
It was enough second time.
The second time round.
And the position's the same with Claire Mello, isn't it?
Well, it's almost identical with Claire Mello, who's on the following page. It's like flying on AA, 2 inches of legroom. Any concerned? Miss Mello, yes, I have a medical certificate. The court, we expect to be finished by that date, though, And then Mr. Mahoney says, stand down. And the court says, wait. Oh, no, that's something that doesn't relate to it. But Mr. Mahoney says, stand down. And then when you look back at Claire Mello being recalled on page 73, Claire Mello, who was traveling on the 24th of March to 31st of March, 24th of April to the 31st, we're not going to be here for that. So that suggests that cause is not established, but we can agree that she can stand by for the time being. So again, but for Mr. Mahoney's decision to stand her down first time round, she wouldn't.
The same point, Miss Greening. You know, this is not really my role, but it's 3:20. We've got a long way to go, and this is our last day.
So that's. Now, do you want me to go through the 13 that I say were stood by without any reason given at the time at all?
Well, just identify, wait a minute, just before we leave this. Okay, you say, but for the prosecution standing her by for the first time, what? If the prosecution hadn't stood her by the first time, we simply don't know what would have happened.
Well, there would have been some discussion about whether or not she should be on the jury, and she might have been on the jury.
But we don't know.
No.
Okay. But in any event, what we get to is two cases.
Here's an example. If you look at page 19, an example to highlight my point. If you look at the bottom of page 19, the court calls out number 3, Troy Baisden.
Yes.
The court says at the end, any concerns, ma'am, that's to do with someone else. And then the prospective juror says yes. The court says yes, question mark. And Mr. Mahoney says, stand down. Now, we later find out when Troy Baisden gets called back, unlike Linda Graves and Claire Mello, isn't as lucky. He makes a big argument about being a Belco employee and not being able to leave his job. And the court says, I don't hear any causes established. You're going to have to take a seat.
Yeah, and he sits on the jury.
Yes, but my point is the exact same thing has happened with Claire Mello, Linda Graves, and Troy Baisden as far as the prosecutor is concerned the first time round. But because they went through the exercise of deciding whether cause could be established with Troy Baisden, and the court decided that there wasn't any cause, he had to sit on the jury.
Yeah.
Whereas Linda Graves and Claire Mello,
yes,
they were stood by time being,
yeah,
because the prosecutor had stood them by, and we'll never know what might have happened if they had to go through the exercise that they were supposed to go through pursuant to the Jurors Act.
Yeah, but the Crown had at least 3. There's nothing wrong in the Crown having 3 rights of standby because each defendant had 3 rights of peremptory challenge.
Right, but my argument is the fact that the prosecutor stood down 13 jurors. It was in an attempt in my submission for tactical purposes, in an attempt to manipulate the jury, has created an appearance of bias that renders the trial unfair. And it just so happens that some of them ended up sitting on the jury and some of them didn't get called back and some of them were excused for cause. But similarly to Mr. Lynch's argument, if the prosecutor doesn't give reasons and just stands by people with no explanation whatsoever first time round, we don't know what's in his mind, and neither does the fair-minded informed observer. And there are a number of these jurors as well, similarly to Mr. Lynch's case, where There were no excuse. There was no reason given whatsoever for a number of them. Then there were another category, a smaller number of people who did give reasons, but the court then decides it's not a very good reason. For instance, traveling at dates where the trial is not supposed to be sitting, and things like that. So similarly to the other appellants' counsel submissions, we've got a number of different categories where if you're the fair-minded, informed observer sitting there watching, all you can see really is that the prosecutor is unilaterally deciding with no input from the defense as to whether those prospective jurors should be stood by or not. Out of the 13 that were stood.
Can you wait a minute? Can you identify who the 13 are?
Yes. And out of those 13, only one came back and sat on the jury. That's Gina.
Can you identify who the 13 are?
Yes, I can. Yeah. I can identify them by listing them out, just reading them out in a list, or shall we go through them in the transcript?
Well, I mean,
not too difficult because it is. I mean, it's not as difficult as other. It's in order at least.
Well, can you list them by their standby numbers?
I can list them by their juror numbers.
Okay.
By their juror numbers, they won't be necessarily on the list. They won't be on this re-amended schedule of jurors challenged necessarily because
if they're not on the re-amended schedule of jurors challenge, presumably you'll be able to give us a transcript reference.
yeah, oh yes, I can. And in fact, it's easier for me to go through the transcript starting on page 12 of the transcript, which is page.
Forgive me saying so, but this is spectacularly unhelpful. You say you don't argue with the Crown as to the number of standbys, those excused, challenged, or who eventually sat as jurors, but you're now about to say that there are a number of standbys who are not on the list.
There are a number of jurors who were called the first time round.
Yes.
Stood by for no reason. Then they came back. I don't know why they're not on the Crown's list. I can't explain why. But
if you disagreed with the Crown's list, why didn't you say so? I mean, this is difficult enough as it stands, but when you say you agree with the Crown and then say, no, I don't, it's singularly unhelpful. Okay, we'll have to go through the 13.
Okay, well, the first 3 are on the Crown's list. So that's, so at the top of page 12, number 14, Joseph Dawson, stand by. No explanation, no.
Okay, right, Dawson.
We can see on the re-amended schedule provided by the Crown that he is then excused by the judge later on when he comes back due to work commitments.
Yes.
But my point is he's stood by with no explanation or excuse given to start with. Sharon Gardner, number 24, just underneath that.
Yes.
Right.
The court says, I see, hold on a minute. And Mr. Mahoney says, stand by. We can see from looking at the re-amended schedule that she's challenged for cause later down the line and stood down by the judge.
Yeah.
Right.
Trevor Smith.
Yes.
Trevor Smith is stood by with no explanation, but then later on explains that his brothers died the previous Friday and he gets excused by the judge.
Yeah.
And it's the bottom of transcript, page 13.
Yep.
Then there's Wayne's, oh, sorry, no, not him. Then there's Michael Wellman. So Wayne Scott Darrell is the next one on the list on the re-amended schedule. He's just excused by the court for knowing the families right there and then the first time round. So he's not one of my 13.
Wait a moment. Well, but he does seem to have come back. He comes back at page 56. Line 23.
Yes, but he's not stood by. He's not one of the ones in the category that are stood by with Mr. Mahoney, with us having no idea why.
Okay, all right. Okay.
And there's Michael Wellman. At the top of page 15.
Number 60.
Number 60, Michael Wellman, Mr. Mahoney, stand down. We know later on that he's excused because of travel and because he had a case with the lawyer, with one of the lawyers in the case. But we don't know anything about what Mr. Mahoney is thinking at the time. We go down a bit to the top of page 17.
What about Correlita Durham on page 16?
Correlita Durham.
Her name is called at line 6 of page 16, and at line 10, Mr. Mahoney says standby.
Yes. Oh, I've got her a bit further down on the list. Yeah, I've just got her next on the list. Yes. So she's also one of the people on my 13.
Okay.
Then there's Ligaya Sanchez Wilson. Mr. Mahoney says stand by. The court says yep, and then the next number is called. We know that she is then called back. Cause is not established, and she sits on the jury. But at the time, anyway, I will repeat myself. He just stands by with no explanation. Then there's Peter Jovatek.
Yeah. Who's not on the list?
Peter Jovatek is challenged by my client.
Where in the transcript that is? May not be necessary to.
Sorry, where is he stood down? Stood by?
Well, page 275 is where he first appears.
Peter Jovatek. Yes, he stand down, followed by Lakia Richardson.
Wait a moment. Are you saying Jovatek was in fact objected to by your client?
Yes, so he went and sat in the jury when he came back the second time round, and he was challenged by my client. But the first time round, well, obviously we don't know that's going to happen. He is stood down by Mr. Mahoney with no explanation.
Right.
Then immediately under that, we have number 44, Lakia Richardson, stand down. Later on, she comes back and she says she knows.
It would be helpful for me reading if you could give the references, if you have them, on the transcript as we're going through.
Lakia Richardson is page 275 of the Record of Appeal, line 12.
And transcript number?
27.
Thank you.
Just a moment. Now, on the list, there, if you look at the third page of the list, stand down candidate number 23 is described as Nakia Richards. Are these the same people? It's certainly the same reference.
Looks to be.
Yeah.
Same numbers.
Yeah. So she's either Lakia Richardson or she's either Lakia Richardson or Nakia Richards.
Yes.
But it's the same person.
Yes, number 44.
Right. Okay, thank you.
Then we've got on the same page of the record of appeal 275, line 19, sorry, line 20.
Yes.
Gina Dean, number 16, Gina Dean, stand down. And immediately after that, Geraldine Roberts, stand down.
Right.
And then we've got on the next page, 276, line 4. Sylvia Bento, number 6, Sylvia Bento, stand down.
Right.
And then at the top of page 279, line 1.
Lord, sorry to interrupt, but just to inform the court that Gina Deans actually sat on the jury.
Yes, we know.
Sorry, who sat on the jury?
Gina Deans.
Yes. But yeah, I know.
And then at the top of 279, Jaquita Rowland, stand down.
Yes.
Sorry, just, yes, got it. That's page 31, thanks.
Yes.
Yes.
And then Tico Hassel is the next one at
Well, Tico Hassel can be found at page 84, Record of Appeal, page 332.
I got it. Page 44 of the transcript, line 17.
Yeah.
okay, so he's called once the defendants start to challenge theirs and there's gaps in the jury, he gets
44, line 17.
yeah, he's called before that.
Yes, 44, line Record of Appeal, page 292, page 44, line 17.
Yes. And he stood down with no explanation given. And then Linda Laws Lucinda Laws on the next page, 293 of the record, page 45 for Justice Bell, and line 8. Lucinda Laws, stand down.
Right.
Well, if I've not double counted someone, I'm already at 14.
So am I.
So am I.
Yes, 14. Sorry, it's 14. So.
And those don't include either Linda Graves or Claire Mello.
Or Claire Mello, correct.
No, I have a whole other, I mean, I'm not suggesting that I go through it unless you want me to, but I have another list which includes all of the standbys that Mr. Mahoney calls out, but that's after the witness has said, after the juror has said something like, I knew the deceased, or I'm a teacher, or I have a medical reason. The ones that I've called just now are the ones where the name is called and he's immediately says stand down. And the reason I'm at pains to highlight this is because, as you know, my appeal rests on the appearance of bias. And when you look at 14 names called out with no discussion whatsoever, and only the Crown standing up and saying stand down, it creates such an appearance of bias on the fairness of the trial that we can't escape it. The fair-minded, informed observer is looking at this process unfolding and thinking, well, look at the Crown, they get to, and whether or not at the end of the day, to use the phrase the President used yesterday, they come back and they explain, it's the fair-minded, informed observer is not in the business of doing that kind of analysis to say, oh, I remember that person came back. Okay, so he's now going, he's now allowed to go because his brother died, or he's allowed to go now because of this or that. The fact is, for 45 pages of the of the transcript, the defense have not said a word. Mr. Mahoney has stood down, as nothing personal to Mr. Mahoney. The Crown has stood by all of these prospective jurors by just simply saying stand down with nothing. And the number, the huge number is what I ask or urge the court to consider when looking at this, the appearance of bias. Then then weaved inside all of that are also the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 18, where the Crown is still unilaterally deciding to stand down before the court has decided whether or not cause can be established. But at least there's been some sort of reason, whether those reasons are good reasons, like Mr. Lynch, I could go through and make submissions on whether, but in my submission, I don't need to do that because the appeal must be allowed on this first stage alone. The fact that the prosecutor has abused his position, his privileged position pursuant to section 519, contrary to the principles, equality of arms, the fairness principles, and the AG's guidelines. I don't need to go into the analysis of whether or not the excuses given by the other 18 are good excuses or not. But I can do so if the court wants me to.
Well, that would be an exercise of whether the excuses given first time round were good or not when they were all expanded second time round.
And out of those 18,
Ms. Greening, I understood the 18 where something was said about the prospective jurors to be different than the 14 that we've previously identified.
Yeah,
am I right on that?
Yes, they're completely different people. The 14, 13 that I have listed just now.
Yeah, I've got it. I've got it. Thank you.
Simply, yeah. The remaining that were called first time round and raised an issue of those, one, Troy Baisden sat on the jury because his excuse for working at Belco didn't fly with the judge. Two of them continued to be stood by, Linda Graves and Claire Mello, and the rest of them were excused. There are a number of them where we are not sure from looking at the transcript what is going on. A note is passed around and then a decision is made, and we don't know now in the course of analyzing this situation for the appeal why they were excused, what the reason was. So I'm not in a position to say whether or not it was a good excuse or not. There are others where we can say, okay, well, he was friends with the deceased, and on occasion, even the defense lawyer will pipe up and say, that's okay, or he's being represented by one of the defense lawyers. And then there are others where the excuse put forward is pretty iffy. But I don't really quarrel with those ones because second time round, the judge then excuses them.
I don't follow that. You say that some of the things said first time round are pretty iffy, but I don't quarrel with that because the second time round the judge excuses them.
Well,
but that appears to indicate that the relevant question is what happens at the end of the day.
Yeah, so the first time round, for instance, Felicia McMahon, number 41, will say, I'm a teacher at a school. I'm the deputy principal of a school. The court says, deputy principal, I've never heard of that person being essential. You just stay where you are for a bit. You might be called back. Then when she comes back, so that's what I would describe under the category of an iffy excuse, that the prosecutor then takes it upon himself to say, stand by to that one. She gets called back the second time round and tells the court a bit more about how she's the deputy principal of the school, and then she's excused. So the court has made it clear the first time round that he's not really buying her excuse for being the deputy principal, and that's not really going to be enough necessarily. The prosecutor then says, stand by, makes that decision himself, despite what the comments of the judge. And when she comes round the second time round, the judge says, okay, well, you can be excused, you're the teacher. So a unilateral decision is made by the prosecutor in the face of the court's comments that that's not really a good enough reason not to sit on a jury. In line with Mr. Lynch's submissions on his various prospective jurors, that just because you work at MJM or at another law firm, or you previously worked at, so what? Does that help to answer that question?
Sorry?
Did that help to clarify that point?
No, it made it worse. I understood you to say that in relation to those where the question was a little iffy as to whether the witness, the juror should be, a putative juror should be stood down, you didn't quarrel with what happened because the judge later decided that she should be stood down. Is that right? That's what I understood you to say.
Well,
sorry?
I see why it made it less clear. I'm still arguing that the Crown abused its position and created an appearance of bias by unilaterally deciding to stand down prospective jurors who have given excuses, but at the end of the day, those people have been excused by the judge.
Quite.
But it still creates an appearance of bias to the fair-minded, informed observer who is looking at the prosecutor standing down dozens of prospective jurors with no input from the defense, regardless of the reasons at the end of the day. We just can't escape that when there are such high numbers. It matters not whether at the end of the day, three people came and sat on the jury, two people never came back. The fact remains that you're sitting there watching something that's supposed to be an adversarial system based on fairness, and it's being abused and manipulated, at least in an attempt to shape a jury for their advantage.
Take it, you're saying the only difference between the 14 and the 18 is that with the 14, no reason at all was apparent the first time around.
The difference between the 14 and the 18 is that the 14 that I've listed and taken the court through are
the Crown simply said
are even more egregious than the other 18, where at least the jury.
Didn't you answer the question? Yes, the 14 was stood by as soon as their names were called. The 18, something was said by way of a reason, good, bad, or indifferent.
Yes.
Whose bias is there an appearance of?
It's the trial process is bias. It's
the trial process is inanimate.
It's the whole process is contaminated. It's like it's injected with a dye of unfairness.
But you still need to say who's being unfair.
It's the prosecutor, isn't it? It has to be the prosecutor that's abusing their position or their privilege, the privileged position.
Well, what is the position if the prosecutor acted unfairly, but at the end of the day, you got a jury in relation to which it couldn't be said that there was any likelihood of bias?
It's the appearance of the.
Yes, but I mean, I'm just looking at the Chief Justice's judgment in Trott, where he says, at the end of the day, I'm satisfied that the disparity between the accused persons and the Crown's right to challenge jurors gives rise to a real possibility that the jury may be biased in favor of the Crown. If there is what you say to be a defect in the process, but at the end of the day, there's no reason to believe that the jury is biased, it can't possibly be said that the accused didn't have a fair trial.
With respect, I disagree. The trial process itself needs to be conducted in a manner seen to be fair, in order for fairness to have, for justice to have been done. It's not enough, as we know, for justice just to be done. It needs to be seen to be done.
Mm-hmm.
And if the Crown, as it has, abused their privileged position contrary to the guidelines and contrary to the fundamental principles, constitutional and otherwise, to the accused, then it amounts to a miscarriage of justice. In my submission, no one was suggesting in the Miller and Dixon case that in fact, in the Miller and Dixon case, there was no discussion about the strength of the cases, the individual cases against those appellants, and whether their convictions were in fact unsafe as a result of, but it was the appearance.
Yes, but that was the appearance of bias of the judge. What was said was that the temporary procurators, or whoever they were,
yes,
it wasn't said they were actually biased, but they appeared to be biased because they had a very
they'd asked for a conviction. Yes.
Short tenure. So the person who was actually going to make the judgment was apparently biased.
Well, my submission a few days ago to his lordships was that the fair-minded informed observer included the prospective jurors that are sitting there about to embark on this important task of being the triers of fact in a very serious case where my client was facing life imprisonment and was convicted to life imprisonment. And they were watching a situation where the prosecutor was abusing his privileged position, and in my submission would have gained the impression that the person or people who were eventually going to be inviting them to convict my client were more in control, had the upper hand. There was an inequality of arms and unfairness about the trial due to the prosecutor's actions that meant that there was certainly an appearance of bias, if not actual bias, because those jurors who are sitting there watching and taking part in this process are those are their first impressions of this process that they're about to embark on.
Bias of whom?
The prosecutor.
Right. So the exercise we've been carrying out for a couple of days to see whether at the end of the day a juror who stood by originally was excused for cause, or removed for cause or excused, was a waste of time.
No, my lord, I don't think so. I think that each of our cases separately turn on, they're fact sensitive, and each of us had to go through our particular facts and make submissions separately and apart from one another, because this honorable court needs to consider and look at the facts and see how those facts fit into. The burden is on us to demonstrate to you that substantial injustice has occurred.
But it is irrelevant on your case whether or not at the end of the day the court decided to remove for cause or excuse. You say the fact that it did so is true but uninteresting.
Yes, and with respect, since I filed my submissions on the 11th of December, that has been my consistent position.
Yes, I follow that. So the effect of that submission, if well founded, is that if the Crown stands by 4 jurors first time round and just says stand by, and when they come back again, the judge decides that each of them should be excused, the die has been cast because the prosecution stood the 4 by without specifying any reason at the time. That is fatal.
Well, the sheer high numbers in my case is what I'm relying on to demonstrate substantial injustice.
Right. Okay.
The high numbers of the conduct of the prosecutor, yes.
Any particular number which counts as high and below which counts as low?
Well, in my case, 14 were stood by with no explanation, 33 were stood by unilaterally by the Crown. And I say that that number takes you well over the threshold, or takes me well over the threshold to demonstrate constitutional unfairness.
Right.
And an appearance of bias, which, as per the case law, there is no difference between the two. That's my argument representing Roberts in his case.
Right. Okay. Yes, well, thank you very much.
In the absence of any evidence to the contrary given by the prosecutor, what other possible reason could there be for him standing down such high numbers with no explanation? And if there was an explanation, wouldn't he have given it? He says he wasn't entitled to. But it doesn't take away from the fact that it's constitutionally unfair and creates an appearance of bias.
On the part of the Crown?
Well, I still think that it creates an appearance of bias. Everyone participating in that process, the Crown, the court, is creating this appearance of bias that is resulting in an unfairness to my client.
I'm terribly sorry, I keep on asking this, but bias can only be a characteristic of a natural person.
Well, it has to be the Crown then.
Right.
Obviously.
So it's the appearance of bias on the part of the prosecutor.
Yes, of course.
Okay. Well, we better hear from Mr. Mahoney.
My Lord, I don't propose to go through all in the interest of time, to go through all the 14 names given, but just to give a few examples of some of the areas that my learned friend actually seems not to have turned their attention to. Let's go to Peter Jovitek at page 275 of the record. 27, that's page number 27 in the transcript.
Thanks, Mr. Mahoney.
And that's at line 5.
Yep.
Any concerns? Something was said, stand down. And in any event, the defendant himself took that person off the jury. So that doesn't count in any event. Counsel made submissions about Ms. Felicia McMahon, that she was stood by the mere fact that she was a teacher or excused. That's not necessarily correct. If one goes to page 59 of the transcript, the electronic page would be page 307. And we go to line 21. Well, actually before that, line 19, Ms. McMahon, I'm also familiar with the accused. or write that down, save me, how you are familiar with the accused. And she wrote her note. Next.
Mahoney, I don't see this name on the list of 14.
Excuse me, sir?
The name McMahon was not on the list of 14 identified.
No, sir. Well, Miss Greening made reference to McMahon. Miss McMahon was excused by the judge.
I don't have a note of her having raised that name, you see.
On the first page of the Crown schedule of jurors.
Didn't raise the name in the 14 that was stood by with no explanation. I raised her name as an example of someone that the Crown stood by on the back of an excuse that wasn't a very good one.
That she was a teacher.
Yes.
That's what I'm responding to.
Oh.
But she's not one of the 14, you're saying, Miss Green.
No, she isn't.
And page 60, based on the note that she wrote, the judge said that at line 4, all right, having seen the note, I think the cause is established. Stand down. I would put it this way, my lord. In looking at the, Miss Greening would want us to have the impression that the total number of standbys related to her client only. As I had indicated before, this was a two accused case in which there are two deceased. One of the deceased was a well-known artist, well-known person in Bermuda. Hence, that's why we had the situation where a large number of people eventually were excused. I'd asked the court not to focus on the numbers of initial standby, but to look at the whole thing, the whole process practically as to, in effect, what was the end result. In effect, 28 people of the 33 could not have sat on the jury panel. That's why they were excused or released for cause. Of the remaining 5, 3 sat on the panel.
Mm-hmm.
Which left 2 persons. And therefore, the fair-minded, well, the putative, informed observer, observing the whole process, would not assume that there was any bias in favor of the Crown. In fact, having heard the excuse and having seen those persons being excused, would probably, well, not probably, more than likely agree that there was, the Crown was justified in standing by majority of those people. And just to make a correction, Ms. Greening said that the co-defendant challenged only 2. That's not correct. It was 3-3 each.
Right.
I don't know if the court need me to elaborate any further. I think.
Well, I wonder if you could help me on this. What is said, as I understand it, is that the prosecution was misusing the court process. And there was therefore an appearance of bias, not on the part of the jury, but on the part of the Crown, or to put it more directly, you. Is there anything you want to say in relation to that submission?
Well, my lord, I find that a bit interesting because the prosecutor, namely myself, was actually doing my task to the highest standard, applying the law as it stood at the time. It turned out that, in effect, the standbys were substantiated, in that of the 33 who were challenged or stood by, 28 were excused for cause. Well, at the start of the submissions, there is some allegation that I was manipulating or stacking the jury and what have you. It seems as if I did a very poor job, because in the end, I ended up with a majority Black panel. And the jury, as directed, are directed by the judge to make their decision on the evidence, not on the prosecutor. And there is no evidence of any abuse of authority. Any experienced prosecutor would know that. This is all just speculation and emotive terms without any substance to it.
Right. Could you just help me on another thing? In your schedule, there are a number of candidates, as it were, who, well, let's take an example. If you look at yes, we looked at on the last page, Tico Hassel and Lucinda Laws. And the thing that I noticed was that a page reference was given for when cause was established, and there didn't seem to be a reference to when the individual was stood by first time round. And we found them in relation to Tico Hassel. It's at page 44, line 17. And we found them at Lucinda Laws, which is 45, line 8. But there are a few others who fall within that category. That's to say, we haven't got the reference for the original stand down. If I can tell you who they are, if you're then a junior will make a note. They are standby number 10, 12, 14, 22, and 29, and 33. It may not matter a great deal, but it would be, in case it does, it would be helpful to find the original standby.
Well, my lord, in respect of I think that was done for most of those you identified in the re-amended schedule.
Yes, it was.
It's the re-amendment is in red.
Oh, help, I haven't got the re-amended schedule. When was that provided?
That was provided with the email that was sent in answer to the requests that were made.
Well, I don't seem to have it. I'm not sure whether any of my colleagues have. I don't know whether Mr. Taylor.
It was sent, my lord, on the 16th of March.
I have it in hard copy, and I don't think it would take very long for me to run through that and just say what the original references are.
Okay.
Which we could do now.
Well, why don't we do it in private afterwards?
Right, that's fine. I've got them.
Right. Now, that is for myself, all the questions that I have in relation to the exercise of going through the standbys. Do any of my colleagues have a question that arises in relation to that exercise?
Not on my part.
Nor on mine.
Could we just look at, if you go to Record of Appeal, page 269, page 21 of the bundle. At line 11, there's a reference to somebody called number 5, Barbara Belton Brown.
Sat on the jury.
She sat on the jury, did she? Thank you so much.
It was number 7.
Fine, that solves that problem. Right. Right, well, I think we're coming towards the end. I have a few outstanding questions on matters that we have already discussed. Firstly, could we go to page 244 of the Record of Appeal? This is 44 of the judgment in Smith Williams. We looked at it a couple of days ago, and in it, Justice Kay says, Ms. Tucker does not exhibit any of the emails or WhatsApp messages. Moreover, her statement about Mohammed's elusiveness during the trial is not wholly accurate. In the course of the hearing, we were told, and it is now agreed, that Mohammed was in fact in the court building on the second day of the trial, and a police officer had made Mr. Lynch aware of this at the time. Now, that appeared to be an indication that the police officer had made Mr. Lynch aware of the presence of Mr. Mohammed when Mr. Hamid was in fact in the court building. Mr. Lynch told us that he did become aware that Mr. Mohammed had been in the court building, but was not aware that he was in the court building at the time that Mr. Hamid was there too. Has there just been a misunderstanding in paragraph 40?
Well, I hope so, my lord. I was looking to see what the affidavit from the officers who provided affidavits for this hearing, none of them say that they told me on the day.
They don't.
And no, they don't. And my understanding, as I say, I can't remember exactly when it was I was told, and I'm happy to accept that it may have been on the day that he was there that I was told, but not while he was there. He was never pointed out to me, and I don't know even today what he looks like. So I can only assume that that is a misunderstanding. I certainly wouldn't seek to resile from the fact that it may be on the very day on which he was there that I was told, but it must have been after he'd left.
Okay, right, that's fine. Next item on the program, could we look at page paragraph 2, no, could we have a look at yes, the reference at page Record of Appeal, page 241. Yes, at paragraph 35 of the judgment, Justice Kay says this: Ryan Ferbert was working with Culford Ferguson on the 4th of February and was nearby at the time of the murder. At first, it was thought that Ferbert might have been an intended victim as a result of an altercation he had some 2 months earlier when his gold chain had been taken by Trey Simmons, and Ferbert had damaged Simmons' motorcycle in retaliation. Just a moment. I have a faint recollection of this, but did Trey Simmons have some gang affiliation?
So, sir. Can I just have a second, please?
Yes.
I don't recall one.
The reason that I asked is that the note that I made of what Mr. Mahoney told me was that Mr. Ferbert said that he had had a prior to the incident, a run-in with some man or some men. The two of them had associations with MOB.
There were certainly other names. I'm not sure it was Trey Simons, but it's the same incident, I believe, that that he was referring to. There'd been some fracas at the school, I believe, and Trey Simons had taken the chain from Ferbert, and he tried to get it back. He got his brother involved, and he went around with his brother to Trey Simons's grandmother's house, where he saw the motorcycle and then damaged the motorcycle in retribution. And then there were further incidents following that, which involved associates of Trey Simons.
Okay.
Whether I don't believe Trey Simons was said to be a gang member, but certainly some of those that he was associated with were. Duante, Darrell might have been one or two others. I certainly invite correction from Mr. Mahoney, whose knowledge of the gang culture in Bermuda is second only to his police officer expert.
Yes, the one.
Sir, the evidence of Troy Harris was that Trey Simons was a part of MOB around February 2011. And Blaine Simmons was associated with MOB. He's a member. And they are both close friends. And Sharoy Fubler was part of MOB. Sharif Hines is an associate of MOB. These are all people in the same age group.
So Troy Harris said that Trey Simmons was part of MOB.
Yes. And Blaine.
And okay, so Trey Simmons sees the gold chain. Ferbert and his brother go and damage Simmons's motorcycle. And there were some other incidents with associates of Trey Simmons who may have had MOB associations. Is that right?
Yes, sir.
It would appear to be.
Yeah, that's all I think I need.
Thank you.
My apologies, my lord. I was just wondering if the Crown could point me to the evidence of Troy Harris's statement in his interviews, if he had that to hand, just so I can double check.
I'm sorry, I couldn't pick that up. Can you say it again more slowly?
I have Troy Harris's interviews in my hand. I remember the only person who spoke about gangs was the gang police officer expert. I don't recall Troy Harris speaking of the boys mentioned by Ryan. So I just wanted to know if Mr. Mahoney had a reference in the interviews that he can point me to regarding Troy Harris's statement.
I asked you to look at his transcript of evidence. He gave evidence on the 9th of October, 2018.
Oh, my apologies. I thought he was looking at interviews. That's the evidence that he gave during the course of the trial.
Yeah, I don't think we need to dwell on this. We could. I take it from Mr. Mahoney. He's got that accurately.
Right. Okay. Thank you. Right. Next item on the program. There's not much more. You told me, Mr. Mahoney, that at the trial there was in the agreed statement of facts, it was said that Mr. Ferbert had said that when he was in the yard, he saw the bike with two persons on it, with helmets and jackets. Can you just remind me what the yard was?
This was the premises that he went up to for refuge.
Yes, that's what I thought.
Yes.
Right. Nearly there. Right, that's fine. Mr. Lynch, I have a question for you. Mr. Mahoney said, what did Mr. Mahoney have to fear? He was an MOB man, or at least he had a large MOB tattoo on his chest. He hadn't actually killed any Parksider, and Ferbert and Ferguson were not Parksiders. So what was he worried about?
This is Mohammed, I take it you mean, President?
Did I not say Mohammed? It is Mohammed, I meant.
Yes, you
yes.
Would you like to make any comment on that?
I can't. I don't have sufficient data to be able to say why he would be fearful. I mean, the realities are, I suppose, is that he. It is said that he had tried to kill. The allegation was that he had attempted to kill one of the rival gang, And in those circumstances, he was fearful for himself.
Yes.
He sets out in his affidavit his own reasons for fear.
Well, but in the most generalized terms.
In generalized terms, of course.
Yeah. Well, I thought you might say that because although he hadn't succeeded in killing a Parksider, that's what it might be thought he had in mind. Right. Okay. Penultimate, well, or either penultimate or pre-penultimate question. There are a number of possibilities as to our decision in this case. One, don't assume anything from the order in which they are put. One is that the appeal is allowed on the constitutional grounds, to summarize it. The other is that the appeal is dismissed. If the appeal or one or more of the appeals were allowed on the constitutional grounds, presumably it wouldn't be necessary to address the question of new evidence.
No, I think the only thing that would be useful, I suppose, would be a decision on principle. You'll appreciate that we have taken the view in drafting these submissions for the admission of this fresh evidence that it is an unusual, both in that there has already been submissions made on that basis and rejected, and now in the light of yet further fresh evidence, i.e. by signing it and an additional feature of the witness statement that was found to be deficient in the earlier ruling, it would be admissible. So as a matter of principle, really, it's whether or not the court would feel able to say, without necessarily considering the merits of this particular application, if it was unnecessary to do so, whether or not this is a route that can properly be taken in the future. Because obviously, as I've sort of been at pains to point out, there is no Criminal Cases Review Commission in Bermuda. And it's really whether or not that residual power will always lie in the right case for the Court of Appeal to reconsider any fresh evidence where it's properly adduced. And it's really a question of is it a case of shutting the door once there has been an appeal, or can that door be reopened?
And in each of the cases, if we were to allow the appeal, we would have to consider whether or not to order a retrial.
Of course, yes. Of course. But obviously, if you were to order a retrial in relation to the constitutional argument, then the individual question of these potential witnesses giving evidence goes away, because they can either come or not. And one would expect that, given the pains that we've gone to, that they would turn up for a trial on the second occasion.
Well, one might. Very good. Now, unless any of my colleagues, either of my colleagues has any questions, those are all the matters that I wish to raise. We're most grateful to counsel for their submissions, which, through no fault of anybody, have taken rather longer than was estimated at the time when this case was fixed.
Yes. Thank you very much.
Thank you very much.
Thank you.